All right. Court is now in session. Judge Christine Hernandez is now presiding.
Good afternoon, everyone. Everyone can be seated. We're hearing the matter of the state of Florida versus Jahara Malik. If the parties could announce their appearances for the record.
Good morning, Your Honor. Or good afternoon, Your Honor. Christian Rodriguez on behalf of the state. Good afternoon, Your Honor. Keimo McGee and Larry Hanfield on behalf of Jahara Malik.
Good
He stepped
afternoon.
out, and Mr. Hanfield stepped out for 1 second, but he'll be back shortly.
Okay, do you,
Good afternoon, Your Honor. Melvin Pearson on behalf of the next.
good afternoon. Does Mr. Hanfield want us to wait for him before we start?
That would be a good idea, Judge. Thank
Okay,
you
so we'll
much.
pass it to
Few
Mr.
minutes.
Hanfield to come back.
And Judge, just so the court's aware, this is Sergeant Santos is just sitting here because it's obviously a packed courtroom.
Right.
So I just, if that's okay with the court.
Okay, good afternoon, Sergeant. I have no problem with you sitting there. I just want to advise everyone in this courtroom, obviously, this is an emotional day for everyone. So I expect everyone to behave and give these proceedings the respect and the seriousness that it deserves. There's going to be individuals that are going to be allowed to speak. I want everyone to be respectful. Please look at your phones, turn off your phones right now, because I do not want any interruptions to affect these proceedings. If there are interruptions, you'll be asked to be removed from the courtroom and you will not be allowed back in. So again, this is an important day for the state of Florida. This is an important day for Ms. Malik, and we need to give it the seriousness and the respect that it deserves. Okay? All right, Mr. Hanfield, good afternoon.
Good afternoon, Judge.
All right, Mr. Hanfield, we're here in the state of Florida versus Jahara Malik. We're here on Ms. Malik's sentencing hearing. Is there any reason, Ms. Rodriguez, Mr. Hanfield, Ms. McGee, that we cannot proceed towards the sentencing?
Not from the state, Judge.
No, Judge. No, Judge.
All right, so on behalf of the state of Florida, Ms. Rodriguez, would you like to give an opening regarding the state's recommendation?
Judge, at
Or
this
would you
point,
reserve?
it's the defense's burden. The state can just tell the court what it's recommending, but I reached out to Mr. Hanfield to see how many witnesses, if any, he was going to call. I did receive 2 reports from 2 doctors, but I don't know if the defense wants to start first since it's down to the
All right,
portrait.
so state, just for purposes of a framework, can you advise the court what the guidelines are in this case?
Yes, Judge, the guidelines in this case are. They are 111.15 months state prison to 30 years state prison.
And Mr. Hanfield, you filed on behalf of your client a motion for variance. You also filed a motion for downward departure as well as a sentencing recommendation with the appropriate evaluations as well as character letters. I understand that state indicated that it's Mr. Hanfield's burden. So I don't know who wants to go first. Okay, so I understand. And what is the state's recommendation as far
The
as,
state is recommending, Judge, 20 years followed by 10 of probation.
so 20 years in state prison?
Yes.
Followed by 10 years of reporting probation?
Yes. So, Judge, I'm in receipt of defense's motion. I'm happy to proceed first. I think just for the sake of the state's argument, under the downward departure statute, you know,
You can proceed with what evidence you have that supports your recommendation, and then upon Mr. Hanfield presenting his motion for downward, I will allow you argument and rebuttal to that.
there is just, I just wanted to clarify with defense what factors he's proceeding under. He didn't articulate any in his motion. It may change sort of some of the questions that I elicit. For example, if he's only proceeding under subsection L, which is just the youthful offender, it will streamline, right, some of the argument and some of the questions. You know, the case law is very clear, right? For example, if he was proceeding under subsection, I think it's J, where remorse is necessary, that's not something that is required under the youthful offender, so that's why I'm just trying to gauge from defense what subsections exactly he's proceeding under.
All right, so Mr. Hanfield, just to streamline, you are proceeding under the youthful offender, is that correct? Is there any?
I would be asking the court as relates for the appropriate sentencing. I will be presenting evidence in support of a boot camp resolution.
Right, but in terms of the motion for downward departure,
It would be remorseful as well as her age, as well as her lack of sophistication and the lack of prior contact in the system.
okay, so you're proceeding under those 2 grounds for departure?
Yes.
All right, state, so in light of that, are you ready to?
Yes, Judge. Judge, at this time, the state will call Sergeant Juan Santos.
All right. Sorry. I'm sorry.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat.
State whenever you're ready. You may proceed.
Judge, if I may provide the court, so at least Your Honor can have a list of the witnesses. I just printed them out, provided them to the clerk. The state's witness for the purpose of downward departure is going to be Sergeant Santos, and should I need to lay any additional foundation, I may call someone else, but witnesses 2 through 12 are next of kin, so if the court wants to hear from them, they'll be available.
I can't see anything.
I'll
Yeah.
turn it here. Good afternoon, Sergeant. Can you please state your name for the record and spell it for the clerk?
Sergeant Juan Santos, first name is Juan, last name Santos.
What department do you work for?
City of Miami Police Department,
How long have you been employed by the Department of City Miami?
14 years.
Can you walk the court a little bit through your background at the city, beginning on sort of where you started and where you're at now?
Yes, I was a patrol officer for approximately 2.5 years. I became a field training officer, which I was at that position for approximately 2 other years. After that, I been 9 years with the City of Miami Homicide Unit.
As a patrol officer, what areas were you stationed or located at?
Mostly Alapad and Little Havana.
And are those the same sort of areas as an FTO?
Yes,
So you've been in homicide since 2017. I know that the court is familiar with sort of a homicide unit, but can you just explain briefly how your team works in the City of Miami?
yes. Well, now as a supervisor, I have detectives that work under me. They get assigned cases, and I just guide them and assist them through the investigation.
And cases are assigned on a rotational basis?
Yes, ma'am.
Over the course of your 9 years in the homicide unit, how many cases have you worked on?
Personally, 19 cases, and assisting other detectives directly over 100 cases.
Judge, in the interest of time, I mean, this is not a trial. I stipulate that he's a detective. I stipulate that he was a detective in this case.
I state.
I understand, Judge. Okay, thank you. All right, so I'd like to talk about the date of incident and the case on which you're here to testify to. At what point, did you get called out to the scene, your department?
Yes, ma'am.
And what are you called out for?
It was a female that had called that she stabbed her boyfriend. By the time that my arrival, the victim was already located and transported to Jackson.
You're a little soft-spoken, so
Oh,
just
okay.
ask if you could just speak up a little bit just to make sure you're heard. Okay, and around what time are you all called out?
So the initial call came out at 11:03 p.m. and I arrived at the scene shortly after.
Can I see the list, please? So, at this time, the state would seek to introduce what has been previously marked, at State's Exhibit 1A into evidence as states 1. It will be subject to counsel's objections as to the one particular item with foundation, which I can present at a later time.
Okay, any objection, Mr. Hamfield?
Subject to that, noted objection, no objection.
It'll be admitted in part, but for the one item that you will lay a foundation for.
Okay,
And state mark for ID purposes, 1A will become State Exhibit 1.
you can keep it because I have everything.
Okay.
Thank you. Okay, Detective, Sergeant, excuse me. So you all are called out at around 11 p.m.?
Yes, ma'am. The initial call, it was 11:03.
And who was the person who made that call?
The person that made the call was the defendant.
And you've had an opportunity to listen to that 911 call?
Yes, ma'am.
For the record, I'm saying it's composite exhibit 1 and it's the 911 call.
Starting date Friday, December 20th, 2024, 22 hours, 59 minutes, 43 seconds.
Your estimate now is 157. Okay, is the person there that's happened? Is the person there that's happened? You had the knife?
Yes, and he like wanted to me. We were playing, and he wanted to me. And he got me.
Okay, what is the address? What is the address in your pocket number?
It's a funny.
Okay, what's the pocket number? What is the pocket number now?
I don't know, it's my boyfriend's place.
Okay, please look at the door. Is there something with a piece of mail or look at the front of the door? Is there something on the door? I'm getting rescue force now. Is there someone else there with you? Rescue force. Rescue team. We are out on the 370 per Atlantic 6130 Northwest 6th Court. 6130 Northwest 6th Court. Oh.
I'm going to pause because the court has had an opportunity to hear the entire 911 call. Sergeant, when you arrived on scene, what did you foresee upon your arrival?
I responded to the third floor of the building. By the time of my arrival, the victim was already taken to Jackson, and it was just the officers securing the scene.
And who was the victim in this case?
The victim was Mr. Lollar,
And how old was he?
17.
And who was the defendant in this case?
Miss Malik,
And how old was she?
17.
So you arrived at the 10th floor. Your role at that point was what?
Just to secure the scene until and assist the relief detectives of the incident.
Did you speak with anyone that day when you arrived?
Yes, ma'am.
Who'd you speak with?
I spoke with some of the officers there and the mother of the victim.
What was her demeanor like?
Distraught. Once I made contact with her, and she was informed of the incident, she hugged me for like 5 minutes. It was very emotional for her. So,
Sergeant, can you just tell the court about sort of what happened in this case, the circumstances around the stabbing?
yes, ma'am. Later, we found out that the offender has arrived at the building.
Starting date Friday.
You see, that's the first arrival. We see the videos from the entrance of the building. The victim comes down, opens the door for her. At some point, they were play. He was opening and closing the door.
Let's watch the record of the this case exhibit. One, the first surveillance footage. And who is that person that's approaching right here.
That
The
is
same
a-
class.
Mr. Rodriguez, can you move it a little, because I have,
Sorry.
it's okay. All right, perfect, sorry.
Who's this person here?
That's the defendant.
And do you know who this person is here?
Yes, that was identified later as Ms. Hunter.
That was the defendant's friend?
Yes.
I'm gonna let it play while you talk about the beginning of the scene, because it needs to be flash forward. At some point, you indicated that the victim comes down and lets her into the building.
Yes, ma'am.
And he's, and is her friend there with her when he lets her in?
She was around that time, yes.
Okay, and then at some point, does the friend leave?
Yes,
And the defendant remains on scene?
correct.
I know Your Honor's had an opportunity to see this particular video, so for the sake of time, this is procedural. All right, so you indicated that the victim then lets her into the building. What happens next?
So then they started playing around, chasing around the stairwell, the staircases, and that's one of the staircases that we were able to retrieve videos of the actual them running around.
Now, does you're sort of in preparing for today, you were able to review the entire police file, including the surveillance footage, body on camera, police reports, the medical examiner report, right?
Yes, ma'am.
Okay, so you're familiar with the building. Were there surveillance cameras on sort of every corner in the building, or were there some blind spots?
No, ma'am. There were some blind spots, and there were some areas that did not have any cameras.
Okay, this is one of the areas that obviously did have cameras, and at this time, around what time is it here?
It's 10:41 p.m.
Okay. So who's the person in the hoodie?
The victim,
And who's the person in the tank top?
the defendant.
All right. So, at any point as you watched this particular footage, was there anything about this footage that led you to believe that the defendant was at any point afraid of the victim?
No, ma'am.
Did she appear to be in any type of distress?
No, ma'am.
And in fact, she at some point is like smiling and joking with him.
Yes, ma'am.
I played the third surveillance footage on State's Exhibit 1. Sergeant, can you tell the judge what that footage is about?
Yes, ma'am. That camera was right over the entrance to the garage parking door. The garage actual doors to the left of that, the camera was above it.
And so we've talked about kind of blind spots. Is there any camera that captures anything that's to the sort of left on this side?
No, there's no cameras in between that pillar or the wall.
And so there's obviously another camera that's back here that captures the
Okay,
area.
okay, Mr. Rodriguez.
There's obviously a camera that's back here that captures the footage from this.
Correct.
What is this on the floor here?
That is the defendant's purse.
Okay. And to the extent that you could see, what is here?
Yeah, that's the first ball of trail that we were able to find with the victim's blood.
This next video does have sound, so to the extent that anybody needs to exit. All right, Sergeant, this video is the angle that's farther back.
Correct.
Okay, have you had an opportunity to view this video?
Yes.
Was there anything that struck you about this particular video? Can you hear anything?
Yes, ma'am.
And what was it that you could hear?
You could hear the victim saying at some point, Jahara, don't.
Jahara, don't.
Yeah. or Jahara stop.
Okay. For the record, the state's playing the fourth surveillance footage on state's Exhibit 1. So I'd like to walk the court through just a couple photos of the crime scene in particular. We had seen this in the surveillance footage. Can you just tell the court what this photo is of?
That's where the victim run out of the pillar. He stops us for a minute. That's the first time we see the blood coming out, and then he runs back towards the pillar.
And when you say back, does he run in the direction behind this car?
In between the car and the pillar.
Okay.
And that's where we found the blood trail.
The blood trail that way.
Yes, ma'am.
Okay. Can you tell the court, I know it's a little hard to see, but what is under marker number 1?
The knife,
Okay. And what's at marker 2?
the phone.
And whose phone is that?
I believe it was the victim's phone.
And this is just the path towards the pillar, and that's obviously blood. Okay, we talked about the pillar, so there's sort of no door here. This has access all around?
Yes, the pillar is a big pillar, but it does have access all around the court.
Okay. I'd like to talk a little bit about the injury to the victim's chest. Did you have an opportunity to review the medical examiner's report?
I did.
What did you learn in particular about the wound?
The medical examiner described the wound to be 12 to 6, which means that's the angle that they use to describe the positioning. The 12 o'clock was the blunt part of it, meaning that the part with that it's not sharp. The 6 o'clock was a sharp one, so it was straight in the chest, a little bit to the left, and it was 10.1 centimeters in depth, which translates to 3.976 of the whole blade.
Do you know how long the blade of itself was?
4 inches.
4 inches. Okay. So so the wound was essentially 4 inches almost in depth.
Objection, let the witness testify.
Overruled. Can you describe everything that the knife went through and how deep it went into the victim's chest?
Yeah, as you can see in the video before, the victim had a hoodie, and obviously went through the hoodie, the shirt, and according to the medical examiners, the soft tissue, and it went into the third rib on the left side, approximately 1 inch in depth, and hit the heart.
Okay. So when we're talking about the way that the knife, we talked about 12 and 6, just so the court can kind of have a visual. The knife is essentially right side up, right? Like the manner in which you would use a knife.
Yes, ma'am. With the sharp on the bottom and the blunt on the top.
And the blunt on the top.
12 to 6,
Okay.
as described per the medical examiners.
I believe, was the knife marked? We could just mark it. If you could hand it to the clerk so she can mark it. I'm just going to show you the next photo, which is a photograph of the victim's injury. Can you just describe for the court where the injury is?
Yes, it's on a little bit to the left side of the chest.
Oh, and that's right here.
Yes, ma'am.
I'm going to play the body on camera from State's Exhibit 1, and it's body on camera 1.
Over here fighting and then
You said you guys are arguing.
Yes, well, we was arguing, we was just like, they fighting and stuff, and I said, he was making me mad, and I said, I had to knock my head, and then he ended up running to it, but I'm not, because he already knew I had, he was trying to get it from me, but he ended up running to it.
All right. You guys are arguing?
No, I don't know.
You know your sister? Listen.
My last
You know your last word? What? So that's, I'm trying to figure out what's going on.
No, like, I need to wake up.
No, they're working. Just relax. Okay.
Okay, if he alive, then what?
Huh?
When we go from there?
We're not taking on this story.
Okay, and then what?
And then we just go from there. We'll see what we wish so. We talk to him and everything. We gotta leave. We gotta wait. You're 17 also? What are we doing?
Like, I don't even know nothing.
Okay, Sergeant, I'm gonna come back to sort of the wound, because I'd like to talk about it in conjunction with the defendant's statement. At some point on this night, was the defendant interviewed by police?
Yes.
And was she Mirandized?
Yes.
And if I showed you that Miranda form, would you recognize it? Would you recognize it?
Yes, ma'am.
I'm approaching the witness with what has been marked as State's Exhibit 1C for identification purposes. Sergeant Santos, do you recognize that?
Yes.
And is that the Miranda waiver form that was provided to the defendant?
Yes.
And did she sign that?
Yes.
And at this time, the state would seek to introduce what has been previously marked as State's Exhibit 1C as State's Exhibit 2.
Any objection?
No objection.
State marked for ID purposes, 1C will become State Exhibit number 2.
Okay, so she was Mirandized and she chose to speak to police. Did she tell you why she brought a knife that day with her?
Yes. She said that she was gonna be riding in Ubers and she couldn't find her pepper spray, and that's why she grabbed the knife.
Okay. So it was essentially for protection?
Yes.
And did she tell you that it was needed for protection?
Yes.
Okay. And so, does she tell you then where the knife was when she first arrived to the apartment complex?
On her purse.
In her purse. Does she tell you why she pulls out the knife?
Separate from the statement that she gave in the camera, to what she said that she was gonna call her friend Tate, and the phone was inside the purse together with the knife, and she grabbed both at the same time.
Okay, so we're gonna come back to, it sounds like you're saying that her statement changes from what she tells police initially.
Leading.
Overall.
So, can you just repeat, because I want to make sure I caught it, why exactly she tells you after she's Mirandized that she pulls out the knife? Because she was also grabbing her phone?
Yes.
Did she tell you how she grabbed the knife?
Yes.
And how was that? I'll let you borrow my pen. You got my pen you can use?
Yeah.
Sort of my pen is a demonstrative.
Are you?
Give me your phone.
Yeah,
Give me your phone.
please, I left mine.
So did she demonstrate for you how she said she was holding the knife?
She did.
And how was she? Can you show for the court?
Basically, she ended up with a knife like this.
Okay, so that's what she tells you she ends up. And does she tell you how high she ended up holding up the knife?
Just like this.
Like this. Okay, so I'm going to ask if you could just do me a favor. Could you please stand up? It's okay with the judge. So she demonstrated for you how she was holding the knife. How high up was she holding it?
She did just like this.
Right here. Okay. And I'm gonna take this from you and ask that you stay there because we're gonna reenact it a bit. Where exactly is the stab wound of the victim? Excuse me.
It's right here.
It's up higher in his chest. Okay. And so
Towards the left.
the victim is how tall? Do you recall?
5'10".
5'10". Okay. And the defendant was how tall?
5'6", 5'7".
Okay. So they're about 3 inches apart. How tall are you?
6'2".
Okay, I'm 5'6", I'm probably wearing 2 inches of heels, so that makes us maybe proportionate to them. So she says she's, correct me if I'm doing this right,
Like that, yes.
she's holding it just like this. And does she tell you she's doing this, or does she tell you she has it here?
Here.
Okay, and then what does she tell you happens to the victim while she's holding the knife?
There was something with the door, the victim opened the door, and just bumped into her.
And he bumps into her. Okay, so presuming that that's the case, does she say that the knife is here? And he bumps into her right here? Okay, is that consistent with the fact that the stab wound is actually up here?
No, ma'am.
Okay, so it would have had to have been up here?
Yes.
Upright, right? Okay, thank you. And that's to say if she was holding onto her phone?
Correct.
Okay. So at some point, you've obviously stated that you've reviewed everything. Does her statement to police change?
Yes, from the first time that I reviewed the video, it definitely changed.
Where does she tell police the knife is when she first talks to them?
In this video with the body-worn camera, she says that the knife was already in her right hand, and she demonstrated as a low grab.
So you say right hand, and where does she demonstrate that it is?
And she said it's
Down here? Okay. Does she tell police at some point a different reason why she pulls out the knife?
I'm sorry?
Does she ever tell police earlier that there's a different reason why she pulls out the knife?
The two versions were that one, that they were play fighting, and then the other one to us, that when she was gonna call her friend, she grabbed the phone by mistake with the knife.
At some point, does she tell police that she gets mad at him?
Yes.
Did she ever mention at any point that she was, during her interview with you, that she was afraid of the victim?
No.
That she felt that her life was in danger
No.
when she was with the victim? Did she ever mention that she was previously battered by the victim?
No.
Did she ever mention previously that he had ever been physical with her?
No.
Okay. So I'd just like to play for the court. Just wanted to make sure the court has an understanding of the angle from where everything happened. So we can see obviously with first, oh, excuse me. I'm just going to disconnect this from the court. Officer, you can see, I don't know, Your Honor can see.
Right, but Mr. Hanfield
Oh,
and Mr. Mahini is not
sorry.
going to see
Let me
that.
just fix this setting. Just give me a court control room. I'll come back, sir. So this is the body of camera when first responders arrived. They're going through the inside of the apartment complex. To your knowledge, were there cameras around there?
Yes.
Okay. And then are there cameras? This is the hallway before they exit into the parking lot. And when you said the door that she was referring to, was this the door that she was talking about during her statement?
No, it was this one.
The one in the side? Was there any CCTV footage that showed her version of the events, essentially?
No.
So we've talked, and if I could ask, we just show defense. Showing defense counsel with their releasing Mark States into that one view.
Any objection, Mr. Henry?
No,
At this time, the state would seek to introduce what has been previously marked as State's Exhibit 1B as State's Exhibit 3.
Being marked for ID purposes, 1B becomes State Exhibit number 3.
Thank you. And Sergeant, do you have scissors by any chance? You could just provide him with scissors. Can you tell the court while you're sort of opening that, you've obviously had a chance to view this, that's a photograph of the knife?
Yes.
Okay. If you could just take a moment to just open it up and show it to the court. If you could just show it up for the court, please. All right, and now she told you all that the way that she was holding that in her hand was essentially like this.
This one.
All right, so I'd like to take a moment to talk about some of the, well, I'd like to show the court. You've had an opportunity to review the photos from the we've talked about the injury to the chest. This is, what is this photo depicting?
That's the victim laying on the ground.
And here's the wound?
Yes, ma'am.
And this is just a closer image of the wound. So when you're saying that it was blunt at the top, sharp at the bottom, this is what sort of the ME was describing.
Yes, basically that means this. You see the cut right there? That's the sharp part, and this is the blunt part.
So the knife went directly into the chest in sort of the right side, the right way the knife was to be held.
Yes, ma'am.
Right. So, I'd like to talk a little bit about the interviews of some of the witnesses, where there are civilian witnesses that your department interviewed as a part of this investigation. Okay, that, I believe it's Montavia Hunter, who's known as Tay-Tay, Cavani Williams, I believe it's AJ, and then it's Lazaro Williams?
Yes.
Okay. Did any of them talk to you about prior instances of violence between the victim and the defendant?
Yes, ma'am.
Can you tell the court a little bit about that?
Yes, at least 4 or 5 of the people that were interviewed stated that they had knowledge about the phones.
I'm going to object as relates to the hearsay nature of it, unless there is basis for those witnesses not being called.
Overruled.
Go ahead.
5 of the people that were interviewed stated that they had knowledge, direct knowledge of the defendant had broken the phones of the victim in 3 to 4 times prior.
At least 3 or 4 times the defendant had broken the victim's phone.
Yes, ma'am.
Was there another incident that occurred with a knife?
Yes, while interviewing Mr. Robbins, he stated that in his house the defendant did the same thing, chased the victim around with a knife until she was disarmed and the knife was thrown on the floor.
And who disarmed her?
Mr. Robbins, I believe.
Did any of those witnesses tell you that the defendant, had pulled out a knife in that case because the victim had either threatened her or done anything to her?
No.
At any point, did any of those witnesses tell you that the defendant, as far as what they could see, right, she was afraid of him in any way?
No.
So were all of those witnesses consistent with their description of those events?
Yes, 3 of the witnesses were consistent with the event with the knife, and they also corroborated the phones being broken by the defendant.
And in all of those incidents that occurred, who was the initial aggressor?
The defendant.
The defendant. Okay. Did you have an opportunity to review Miami-Dade public school records?
Yes.
And those are included as in the State's Exhibit 1. Did you review an incident related to the defendant's suspension?
Yes.
Did she at some point tell you during her interview with police the reason for that suspension and sort of the fight that happened?
Yes.
And what did she say?
She said that her and her friends were at the mall, particularly a store called Spencer's. I guess her friends tried to steal some sexual toys, and they got caught at some point. The police got involved. At school, their friends blamed her for getting caught. And then the person that she directly got into the altercation with the school started spreading rumors that they were stealing for her, that they took the blame for the defendant, and that's what actually caused the fight.
And did you have an opportunity to read the offense incident report of that
Yes.
that fight? And what, if anything, does the defendant say with respect to what happened in that incident?
Judge, just for the record, I'm going to object. One, I don't think it's relevant. It's unconnected to this case right presently. And as such, again, even though I know that there's some hearsay that is permissible at the sentencing hearing, this is now relying upon information that someone else said to someone else that he is now relying. And that would be my basis.
All right, Mr. Hernandez, I'll note your objection for the record. I'm going to overrule it, but what's the time frame of this suspension?
I believe that it happened in October. I can pull the record.
October 23rd.
October.
Same year.
So 2 months before.
Can you just describe what she states happened?
Yes. Basically, she said
Just for the record, who's the she?
the defendant.
The defendant.
The defendant said it to the officer. It was time for lunch. I walked out of the door. I threw the first punch, and we started fighting.
And have you had an opportunity to review the video of that fight?
Yes.
And for the record, I'm playing what has been entered into as State's Exhibit 1, and it's the record labeled fight at school. Officer, have you had an opportunity to review a text message between the defendant and a prior boyfriend?
Yes.
Okay. Subject to link up, Judge, I would just ask to publish it to the court. Okay. What, if anything, is of note in that text message?
My objection.
Yeah, I'll note your objection. It's subject to link up.
Okay. Can you just walk the court just through the text messages and sort of what is said, and I'll sort of direct you to the first gray bubble.
She's basically saying that I don't even know how to translate.
You can just read it directly.
I just saying I think you wanna keep your life how it is.
And then the next is I stab N-word.
Yes.
Okay. And then the next message that she responds is I want blood.
Correct.
Okay. And then she notes that
Yeah, the person replies, "You're not about that life."
yeah, you're not even like that. And then she's then retorts at some point, you better ask SMB or fuck around and find out.
Correct.
Okay, bear with me just a quick indulgence, make sure I asked everything. And at some point, Sergeant, the defendant is ultimately arrested in this case.
Yes.
And Judge, I think at this time the state has no further questions for Sergeant Santos.
Any cross-examination?
Yes. Good afternoon, Detective.
Good afternoon, sir.
I'm going to start from where you left off. You just identified a text message for the court. I noticed, I'm aware that you took, and I say you, meaning law enforcement, as part of this case, you had custody of Ms. Malik's cell phone, right?
Yes, ma'am.
And you also had custody of the victim's cell phone.
Yes.
Did you go through those cell phones?
Not me personally, no.
Did you direct, as the lead detective, that since you took possession of those cell phones, did you do any investigations as relates to the contents of those cell phones?
Yes, both cell phones were taken to the Secret Service. The victim's phone was open. The victim's phone's all information was downloaded. However, the defendant's phone was locked. The Secret Service wasn't able to obtain any information from that phone.
All right, so did you request permission for purposes, since you had possession of the phone, to try to get inside that phone?
Not me personally, no, sir.
As the lead detective, did you request anyone to get permission to get the contents of that phone, since you had it in your care and custody?
I wasn't the lead detective at the time, no, sir.
Do you know, even as you sit here today testifying, my client's cell phone is in law enforcement care and custody, correct?
Yes.
And you never bothered to try to get the contents of that phone?
We did, sir. The phone is currently sitting at the Secret Service. And it was being tried to broken into last month. I could give you a second. If you give me a second.
When did this incident happen? When did you take possession? When was the phone taken into law enforcement possession?
I'll tell you right now.
Let me see if I can help you.
Yes.
The cell phone of Ms. Malik was taken into custody the same day. Isn't that correct?
I'm not sure, sir. I wasn't part of that.
Okay. But this incident happened in 2024, right?
Correct.
We're in 2026. So as you sit here today, as far as your understanding, no one has gone into get to retrieve the contents of the cell phone belonging to Ms. Malik.
Correct. I got the answer, actually, the quick response to that from the Secret Service, if you care to hear.
So again, no one has gone into, have been able to get any information, correct?
Correct.
Okay. Now, you did have accessibility, as you testified, that you went through the cell phone of the deceased, correct?
Not me personally, but
when I say you, I'm talking about you representing the police department here, right?
Yes, sir.
The medical examiner's office. You giving testimony from him, even though you did not perform the autopsy, correct?
Correct.
And so therefore, as you've been given questions and answering questions by other people, what other people said and done.
Objection, Judge. Argumentative.
No.
Overruled.
I'm asking you the same thing,
yes,
okay? Sir. Now, the text message that you just referred to, did it identify anything as relates to Jahara Malik?
No, that I could see, no.
Did it identify her cell phone?
I'm sorry?
Did it identify her cell phone number that law enforcement still have in custody?
No.
So therefore, you have no personal knowledge of knowing that line of communication that was just presented to the court. You have no idea who the two individuals, both individuals, when they were communicating. You can't attest on the oath that you know who those individuals were, correct?
Correct, not me personally, yes.
Now, your investigation also revealed that Jahara Malik and the deceased had they had a relationship going on, right? And as part of that relationship, they would often, as far as your understanding, horseplay with each other.
Yes.
And in that process of horseplaying, what they engaged in was immature conduct, right? Would you agree?
Yes.
And part of that horseplaying was Jahara would pull out a knife during the horseplay, and they would run around and laugh at each other and chase each other. That was something that they had a pattern of doing.
Objection, Judge. Lacks personal knowledge. I don't think that that's exactly what he testified to.
But I'm
If
asking
you
a
know-
question.
If you know, based on your investigation. Mr. Hanfield, don't argue with Ms. Rodriguez, just address the court. If you have a response to the objection that's raised, I will hear it, but I do not want you speaking to each other.
That was the defendant's statement, sir.
And as far as the defendant's statement, there were other individuals that said the same thing, right?
Correct.
Okay, so when you say that was the defendant's statement, it was not just the defendant that made that statement. Your investigation from others supported that statement, correct?
The presence of the nephew, sir.
Yeah, is that correct?
Yes, sir.
Now, on the date in question, you saw the video, and clearly, Ms. Malik, while engaging with the deceased, they were horseplaying, right?
From the staircase, yes, sir.
Yeah, all right. And from what you observed, that what we saw was individuals just acting in a manner that had been previously described.
I don't know.
Well, based upon what you saw,
Yeah, it looked like they were, yes.
looked like they were
running.
horseplaying. As
On the video.
yes, as indicated by what my client indicated to you, right? And what she indicated to you was supported by what you actually saw in the video, right?
Yes.
Now, clearly, on the date in question, there was no evidence whatsoever that established for you that prior to the arrival of my client, their whole purpose of being together that day, number one, the deceased was expecting her, right?
Correct.
And she was made arrangements where they were going to, well, she communicated that she was coming over there, right?
Yes.
And so therefore there was no animosity, there was no anger, there was nothing that would support that where she, based upon the conduct shown by both of them, that there was no ill purpose of her going to that, to see him that day, right?
Correct.
All right. And so it's important, just so we understand, that on the date in question, the video shows and corroborates what my client told you. She went there, not for no ill will, not for no ill intent, and in the midst of this horseplaying, that's how the stabbing took place.
Yes.
Now, obviously, the 911 call also illustrate and demonstrate the hysterical nature that Ms. Malik experienced when she realized that her friend had been stabbed on that day. You heard the 911 call, right?
I did.
And you heard the hysterical, the crying, the trauma in her voice, right?
Yes, she was screaming, yes, sir.
And you learned also as part of the investigation in this case, that not only did she call 911, but the first thing she did was try to save his life by trying to life-saving measures on the deceased.
I don't know that part, sir.
What, you mean you don't know that part?
Right,
Isn't
I'm
it?
gonna ask, I don't wanna remove anyone, but I cannot have these proceedings go on and have commentary from the gallery. I started this proceeding with advising everyone that we need to give this a seriousness, so you need to keep your mouths closed and your thoughts inside your heads. I know this is very emotional for everyone, but I cannot, the record needs to be clear. Mr. Hanfield needs to be able to ask his questions, the sergeant needs to be able to give the answers, and we need to keep a clear record of what's happening here, and we can't do that if there's noise from the gallery. So I'm just giving you, this is my last warning. I don't want to have to excuse anyone from this, so please. All right, Mr. Hanfield, I apologize for interrupting you.
Thank you. May it please the court. Sir, based upon that's in the investigative report, three things was done as relates to right after Jahara Malik realized what had happened. One, 911 was called. Is that correct?
Yes, sir.
Okay. Two, life-saving measures for purposes of compressing, trying to stop the bleeding. Isn't that correct?
I have no knowledge of that, sir. I haven't read that part.
And the
Would you mind
third
if I
is
look
making sure that the mother was notified
for the mother
of the
victim?
deceased.
No, sir. She was not.
So, as part of your investigation, you're telling this court that you were unaware that there were life-saving measures done by my client, and you were unaware that she wanted to make sure that the mother was also notified. Are you saying that, no, hear what I'm saying, are you saying under oath that as part of whether you did it or someone else made a notation in the investigative report, are you saying that you were unaware of those two things, other things that were done by my client?
Yes, sir. I was unaware till now. If you, like I said, I could review it in the report. I was unaware of that. I don't know what part of the report. You refresh my memory. I'll be glad to see it. And the other one, she did not make contact with the mother. We did.
I just want you to answer the question.
I'm answering, sir.
As to what you're saying that you were unaware, right?
Correct.
Okay. Now, how many individuals were working as detectives?
The point, I believe it was 3 detectives.
And who would be considered the lead detective?
Detective Acuna.
So you were not the lead detective?
No, sir.
And one thing as detective, don't you all have team meetings when you're going through evidence to find out what one person has done, what the other person has done, gathering evidence?
Yes, sir. I wasn't part of that team directly. I work overnight. I was just assisting that team the day off.
So you're saying that your involvement in this case was solely based upon assisting on the day of the stabbing?
Yes, sir.
And so therefore, that's why you have no idea of what the further investigation revealed.
As far as the CPR, yes, I have no idea.
And so if I understand correctly, and then I'll just move on, because otherwise I'm wasting my time. You didn't do any investigation.
I did on the day of.
Only the day of?
Yes, sir.
Okay. And that investigation that you participated in was very limited. Is that correct?
Yeah, it was including interviewing the defendant.
All right. So did you attend the autopsy?
No, sir.
So everything you talked about based upon the medical examiner is based upon something that you had no personal knowledge of?
Yes, I reviewed the medical examiner's case file.
Well, I can do that. Anybody can do that. I mean,
Objection, Judge, argumentative.
Yeah. Mr. Hanfield, just to pose the question, Mr. Hanfield. You can make argument later on, but just asking the question.
you know, as a detective, right, that it is the detectives attend the autopsy, correct?
Yes, sir.
Okay. So because you were not the lead detective in this case, you had no reason to attend the autopsy.
Correct.
And so therefore, would it be fair to say that you called as a witness for the state, you were not the lead detective, right?
Correct.
You did no further investigation other than what would happen that day.
Correct.
And then as it relates to the questions and answers that you provided through the state of Florida in reference to this text trail, you have no idea where that came from? Is that correct?
Yes.
And you have no idea who the two individuals that were actually texting?
Objection, Judge Aston answered. Over.
Yes.
Okay. And as a result of that, you cannot tell the court that one of the parties of that text message was Jahara Malik. You have no personal knowledge of that, right?
Correct.
I have nothing else.
Ms. Rodriguez, do you have any redirect?
Just briefly, Judge, a couple things I just wanted to ask. Sergeant, Detective Acuna, is he still in the homicide unit?
No, ma'am.
I just want to go back briefly to the defendant's cell phone. So you stated that the cell phone was impounded, and can you just clarify that there was an attempt made to get into her phone, but the department was unable to?
Yes, ma'am. The person in the Secret Service, the one in charge of unlocking the phones and all that, sent me this is the email of the excuse. It says that the phone was an iPhone 14 Pro Max that belonged to Jahara Malik, that is logged with an unknown password. Further examination of that phone has been canceled, and it has not continued to be supported for brute force by either device tool we have at the lab.
And in your experience, the homicide detective, when they tell you brute force, essentially they cannot get into the phone.
They can decode the password.
They tried, but they couldn't.
They tried for over a year, yes, ma'am.
For over a year?
Yes, ma'am.
Okay. And in your experience as a homicide detective, you've impounded many phones?
Yes.
And there have been phones that you've done search warrants for to get into those phones of defendants or of witnesses?
Yes.
And is it very common that it takes a long time to get into cell phones?
Yes.
And is it common that, and is it sort of, does it happen, I guess, excuse me, I'll rephrase it, that there are times when you can't even get into cell phones?
Correct.
And sometimes you could get into a cell phone, whether it be a year, sometimes it could take 20 years.
Correct.
Okay.
Judge, I'm going to object to that just based upon the fact he's not an expert. He cannot give no opinion as far as the technology to get into the phone unless the predicate is laid him as an expert.
Yeah, no overrules the objection.
I just want to talk briefly about the horseplay and sort of the questions with relation to the nature of the relationship between the victim and the defendant. You testified on direct that you've obviously reviewed all of the reports. While you weren't the lead, you were present for the defendant's statement.
Correct.
And you've been able to review every single report, including the lead report in this case.
Correct.
Which was Detective Acuna's report.
Yes, ma'am.
Where multiple witnesses were interviewed with respect to at least the nature of the relationship between the two parties.
Correct.
And in each one of those interviews that you took, you said that the statements of those witnesses were consistent.
Yes.
And they were all consistent in that during all the incidents, the defendant was the initial aggressor against the victim.
Correct.
And on the incident when she pulled out the knife, I think defense counsel asked you about horse play, whether that was from, you had said the defendant's statement, right? So that was from the defendant's perspective.
Correct.
Okay. And the nature of their entire relationship, right? You weren't there for it. You're not familiar with it. You weren't there for the 8 or 9 months that they were dating every day and day in and day out. Okay. Yes, right?
Yes.
Correct? Okay. And when you took her statement, at any point, did she tell you that, well, I'll strike that question. And the night in which you were present, part of which she was interviewed, and in the body-worn camera that you reviewed, you had stated previously on direct that she changed her statements to police.
Correct.
In the reasons why she pulled out the knife.
Correct.
Okay. And I think defense counsel asked you if the videos were consistent with the defendant's statements about what happened that night. I want to go back to something that we talked about earlier. She told...
objection?
Yeah, my objection is that's outside of what I cross-examined. She's now going into areas that I did not cross on.
Overruled. You can proceed.
So she tells you that the knife was here while she was holding her phone in her right hand.
Yes.
Right, and it was at this length. And for the record, I'm holding it sort of below my chest and in between kind of my hips. So she at no point told you that it was up here.
No, she didn't put it straight enough.
And again, you reviewed the autopsy, you were present on scene, you were able to see, you watched the interview, present for the interview of her, you're familiar with her height, you're familiar with the victim's height. The victim was taller than her.
Yes.
Okay, and he was stabbed where exactly?
Right above
In his-
the chest,
in his-
center mass, a little bit to the left.
Center mass to the left, okay. So is the stab wound consistent with where she told you she was holding the knife?
No, ma'am.
Objection. Objection. He can't give his opinion.
Overruled.
And when she first tells police, you identified on body worn that the knife was down here, is that consistent with the fact that he has a stab wound in his chest?
Not even close, ma'am, no.
And the fact that the knife, and you reviewed the ME's report, based on, and you had an opportunity to see the knife yourself, and you know the length of the blade itself, which you said I believe was 4 inches.
4 inches.
Okay, and how deep the knife went into his chest,
3.976.
which is almost the full blade.
Less than an eighth before the end of the blade.
Is that consistent with her version of he merely walked into the knife?
In my opinion, no, ma'am.
And
Judge, only just for the record, I'm going to object about his opinion.
It's noted. Overruled.
And then with respect to life-saving measures, again, you've reviewed Detective Acuna's report. To your knowledge, is that listed anywhere in Detective Acuna's report?
No, ma'am.
And you're obviously familiar with documenting. I know that not all officers are the same, but presumably he would have documented, right, everything that he felt was relevant and necessary and that he knew.
Yes, ma'am.
If that had come out in the defendant's statement when she met with you, is that something that you recall her saying?
Yeah, I don't recall.
And you reviewed her statement prior to obviously testifying today, which you were present for? Okay. I have no further questions. Thank you, Sergeant.
Is the sergeant excused?
For the state's purposes, he is.
All right, sergeant. Thank you. You're
Judge,
excused.
can I have one just...
Sure.
On the issue that I asked you about in reference to my cross view about the phone, you indicated, now, did you ever, as far as you or anyone else, try to get the passcode from Jahara Malik?
Not me. I have no knowledge of anybody else. Me personally, I don't think so.
But you were present when the phone was taken, right?
No, sir.
You were not present?
No.
How do you know the phone was taken?
It's on the reports.
Okay, and did anybody ever ask to your knowledge, permission to get the passcode?
No, that I know. No, sir.
Are you aware that she had counsel present and gave the passport? Are you aware?
No, sir.
That she gave the passcode, gave permission when she gave the phone?
No, sir.
Was a subpoena, now, in order to take a phone, you usually got to get a subpoena, right?
Yes, sir.
Okay, but that was not necessary in this case, right?
I'm not sure, sir.
You said you were the one who was dealing with everything that day when you
No,
responded.
sir, I did not say that at all.
Okay, well, you don't know anything about whether or not anybody even asked permission from Jahara Malik to get for a passcode, right?
Correct, now that I remember now.
She gave her phone willingly, right?
I'm not sure, sir, I wasn't there. They didn't give it to me, so I can't testify to
I
that.
didn't say whether she gave it to you.
Oh.
You said that the phone was taken the day of the incident. That was in law enforcement possession from that day, right?
I didn't impound anything with that phone, that's what I'm trying to say. I have no knowledge of the phone. I did not impound the phone. I didn't turn it into a Secret Service. That's out of my expert opinion because I have no knowledge of that phone. I did not take it, I did not impound it.
Okay, you did not take it, you didn't impound it. I understand that clearly. But you have no information. In other words, you were trying to give an explanation as to why, even to this day, no one has no knowledge of the contents, but you cannot say whether or not, whether law enforcement never had the passcode.
Exactly, I can't tell you because I don't know.
So as far as you're concerned, they could have had the passcode, right?
They could, but I don't know.
But as far as you're concerned, no one was able to get into it, right?
As far as the report that I have from the Secret Service, that's correct.
Okay, but you were able to get into the passcode of the deceased, the victim, right?
Yes.
And in the process of going through that passcode, there was no information for purposes of showing any problems going on between the deceased and Jahara Malik, right?
No, that I could record, no.
Nothing. Thank you.
You're welcome.
Right, Sergeant Santos, you're excused. State.
Judge, I have one doctor that has to leave. We'll be quick. Dr. Brennan.
Does the state have any objections to taking Dr. Brennan's testimony? Okay.
Thank you.
And state exhibit 1 encompasses everything that was previously provided to the court.
I just combine everything as a composite exhibit into one to make it for ease for the record.
Okay. Dr. Brennan, please come forward. Good afternoon.
Good afternoon. Oh, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat.
All right, just for purposes of the record, we're going to take Dr. Brennan out of turn. He's Mr. Hanfield's witness. So, Mr. Hanfield, whenever you're ready.
May I please support? Good afternoon, sir.
Good afternoon.
My apology on behalf of the court for we've been here and we will take you out of term just based upon your schedule.
No problem, Your Honor. I appreciate the courtesy.
Would you please identify yourself to the court?
Michael Brannon, B-R-A-N-N-O-N.
And Dr. Brennan, what is your background?
I'm a psychologist. I have a bachelor's degree in psychology from Doe University, 1978. I have a master's degree in psychology, 1980, from Doe University. I completed my degree requirements for my doctoral degree in clinical psychology in 1988. Spent a year of an internship working with severely mentally ill individuals at the Northwest-Dade Community Mental Health Center, and then was licensed as a psychologist in 1990. So I've been working as a psychologist since that time.
And during that time, have you ever been testified in the judicial system and criminal justice system in the state of Florida?
Yes, sir.
Miami-Dade County, the 11th Judicial Circuit, where we are part of.
Yes, sir.
Approximately how many times?
So at last count in both state and federal court, I've testified in proceedings over 1,700 times.
And doing that 1,700 times, how many times have you provided expert testimony on behalf of the state of Florida?
So
By the state attorney's office?
I've measured it 4 times for federal cases over the years. Each time it was very close to about a 52, 51 to 48 or 49%. It's pretty even, not on purpose, but somehow it's just kind of worked out that way. But twice it was slightly in favor of the government or the prosecution, and twice it was slightly in favor of the defense.
All right, so therefore you're one of those experts you will testify if called upon by the state, as you've done before. And in this case, you were called upon to conduct an evaluation as relates to Jahara Malik, correct?
Yes, sir. I'm hopefully going to give the same testimony no matter who hires me in terms of my not being biased and being straightforward and empirical in my opinion. Yes, sir.
All right. Judge, I will tender him as an expert.
You proceed.
How did you come, do you see Jahara Malik in court?
I do.
All right. You tell the court how you came to make contact with her, and then walk us through what your evaluation revealed. So just basically, in the interest of time, tell me exactly how did you get involved in this case?
Yes, sir. It's your request, Mr. Hanfield. On 5/22 of 2025, I accepted your invite to be involved in a mitigation, a psychological evaluation for purposes of possible mitigation for something here, for instance, in a sentencing hearing.
All right. And walk us through your evaluation.
Yes, sir.
And then we'll talk about your findings and then your recommendations to the court as relates to this case.
Yes, sir. In a brief summary, so I had a number of sources of information that are represented on the first page of my report under sources of information. I had the complaint or arrest affidavit where I read about the offense behavior that had occurred in 2024, December the 20th of 2024. I also spoke by telephone to Ms. Malik's parents, both her mother and father. Also spoke to the therapist as well that she was seeing at that time, her primary therapist. She had seen a prior therapist, but I talked to the current therapist that she was seeing. And then when I saw her, her being Ms. Malik, on July the 7th of 2025, I did a clinical interview and a mental status examination. I conducted several psychological tests, specifically the Minnesota Multiphasic Personality Inventory Adolescent Restructured Format and the Milan Adolescent Clinical Inventory, 2nd edition. Those are both tests for individuals under the age of 18. She was 17 when I saw her.
Now, why is that important?
Well,
Distinguish.
yes, sir. It's important that you give a test that's normed for that population. There's some tests that are developed for adult populations, and then there's others specifically for juvenile populations. So you have to make sure that the test you use is matched up or standardized, is the term we used, for the proper population.
Okay, go ahead and finish telling us what you did.
Yes, sir. And then the last thing I did was a test called Reliable Digit Span, which was one of the measures I used for validity, or whether or not I was getting a reliable reporting on the testing that I was doing.
And why is that important?
Well, in a forensic setting, like we are here, a criminal setting, people have motivation to not tell the truth. In this setting, in a criminal setting, people have a tendency to want to try to avoid any kind of punitive sanctions by being dishonest. Many of the tests that we use forensically, that are generally accepted, have what's called validity scales. And those validity scales are their assessments of how they're approaching the test-taking situation. Are they minimizing their problems? Are they maximizing, like lying, or what we call malingering, their problems? Or are they just randomly responding, not paying attention to the test and just kind of tic-tac-toeing the responses? So we know how people respond when they do that, and that's what we're assessing by those scales.
I would call it sometimes gaming the system. Or
Yes.
trying to game the system.
Yes, sir.
Okay, for laypersons.
Sure, it's not a technical term, but it means the same thing. Yes, sir.
And so therefore, your experience with all of those things, and that's why it's important as the tester to determine the validity so it can guide you in reaching the appropriate conclusions. Would that be correct?
Yes, sir. We want to know if we can rely upon those results. If the person is, let's say, feigning mental health symptoms or giving you unusual selections or combinations of mental health symptoms, you know that doesn't match up with what we know about mental illness and mental health symptoms. So that's why it's important for us to know, can we rely upon what they follow the validity scales with?
All right. So walk us through exactly the different tests, and then what was at the end, what was your assessment and your appropriate recommendations to the court?
Yes, sir. So the best practice standard for forensic evaluations is to include multiple sources of information. So in this case, I had interviews with family members as well as with her therapist. I also had psychological test data with validity scales and clinical interviews and mental status with Ms. Malik. So I relied upon those to see if there was a line of parsimony through all of those sources of information that would allow me to make some type of clinical diagnosis. So for instance, on a test which I'll now call the MMPI-ARF for abbreviation standpoint, it's the first one that I mentioned, there was a valid profile, meaning no indications of faking or feigning mental health symptoms or being defensive. So I knew I could rely upon those results as suggestive of things that she was genuinely experiencing. The test, in summary, showed significant emotional distress, especially in the areas of depression and anxiety, but also showed elevations that were strongly suggestive of a trauma-based disorder, someone who had been traumatized by something that had occurred to them. So that emotional distress and indications of trauma began to lead to certain diagnoses, which were important to know. I gave a second test also with validity scales and those same type of clinical scales for other reasons, but to see if it validated the first test. On that second test, which I'll now call the MACI-2, that test also showed accurate validity scales, meaning no indications of feigning or faking symptoms or exaggerating symptoms, but more importantly, again, symptoms of depression and anxiety, suicidality, and also, once again, indications of trauma. So those tests matched up. Two different tests with two standardization samples matched up in regards to there was no attempts to purposely distort her answers, and they matched up pretty clearly in terms of what significant symptoms were being reported by the examinee in this case.
And let's talk about what is significant, if there exists, when you're dealing with someone with, in this case, conduct, which at the age of 17, in this situation, this type of what you learned in this case, what is significant as relates to the brain, intellect, risk behavior, compulsive behavior? Talk about that.
We've learned a lot over the years about that, although psychology has been studying that, developmental psychologists have been studying that for decades. The law has really become more aware of that through juvenile resentencings and other types of hearings, the Miller case in Alabama, the Graham case here in Florida, the Roper case, all of those reference those many decades of developmental research. And what it really talks about to us is that the human brain is not fully developed till about the age of 24, 25, with some variations, may get a little higher than that. We know the brain grows from the back to the front, and we know that the last areas of the brain to develop, the very front, or what's called the prefrontal cortex, that area controls things called executive functioning. Executive functioning is things like impulse control and being able to anticipate future consequences, decision-making, judgment, ability to be able to resist influence from peers. So all of those things that are kind of like the brakes on a car are the things that last develop on someone's brain, whether you be male or female or smart or not smart, it all kind of functions the same way.
And as relates to dealing with risky behavior, engaging in risky behavior at the age of 17, that could be life and death situations.
So much more likely to engage in risky behaviors. That's why, for instance, insurance rates for automobile drivers who get their license at 16 are much higher, because insurance companies know through actuarial scales that the riskiest behaviors happen at that early time, whether it be driving or other types of activities. And it's for the very reasons I was saying before. It's the brain is not as prepared to interpret or anticipate consequences of behavior. And there's a higher rush of adrenaline, more need for excitement during that period of time. So you see those behaviors happen. Some exhibit them more than others, but for all kids, they have more of a potential to engage in impulsive, risky behavior up until the age of about 24 or 25.
Now, what was your assessment as relates to Jahara Malik in this particular case?
Well, here's what was unique. What was unique is that there was no pre-morbid history, pre-offense behavior that would suggest or predict this. So oftentimes when we do these evaluations, you can see a long history of school problems, or a long history of fights or gang memberships or rule violations where the person's been arrested, in detention center before, incorrigible at home, parents are reporting out of control behavior, can't follow rules and regulations. Here you really have the opposite. You have no real major problems or difficulties in school. You have no major problems being reported by the parents at home. You have no difficulties in school that, excuse me, got her removed from school. She even was employed by family members. So you see someone who was functioning very well before the offense behavior, and not anything that you would predict based upon the outcome of what happened in 2024.
And now, what about her demonstrated demeanor as relates to remorseful, talking about what happened on that fateful day?
So she certainly expresses the things you'd express for someone if they're going to be remorseful. You never truly know how anyone's feeling, but she certainly exhibits the behavior suggestive of that. She's certainly tearful, and when I speak to her therapist also told me that she'd been working hard on those areas. She'd seen her, I think, 14 times by the time I had spoken to her, and that she had processed that. She still felt she needed to do that. The other thing I'd say in response to your question, Mr. Hanfield, is just the diagnosis that I eventually gave her, which I know you'll get to, which is a trauma-based disorder, suggests some degree of remorse and reflectiveness about what happened. You don't exhibit things like traumatic symptoms without having processed what happened and feeling badly about it. Depression and anxiety you can feel without feeling badly about something. You could just be depressed or anxious about your legal situation. But trauma is something different. So if you've endured or come up with a trauma-based disorder, which was diagnosed before she ever got to me, that usually is reflective of she has some degree of remorse or regret for what she's done.
And what were your finding and recommendations to the court as relates to Jahara Malik?
So based on the manual that we use to classify mental health disorders, the Diagnostic and Statistical Manual, 5th edition, text revised, in my opinion, the best fit is what the diagnosis she was previously given by another therapist. Post-traumatic stress disorder, I think, is a fit based upon the test results, what her parents reported, what she presents. I also think that major depressive disorder is an appropriate diagnosis. And I think generalized anxiety disorder with panic attacks. So she has 3 separate DSM-5 TR classifications that I think are all clinical entities that she was receiving treatment for when I first met her.
And your recommendation as it relates to the courts?
If the court is considering treatment as an alternative in this case, the appropriate treatment plan would be to continue an individual counseling. I think she needs it on a weekly basis, as did her therapist when I spoke to her therapist back at the time of the evaluation. She needs specific trauma-focused treatment with someone who's specifically trained in that area of trauma resolution. There's a number of wonderful therapies that are used in order to be able to address that. Her family, who is very supportive and very involved, they need to be involved in the treatment process as well. I thought it would be a good idea for someone to continue to monitor the possibility of suicidal ideations. She's had certainly thoughts about suicide. She scored on a test scale on the MACI, on the suicidal range, and she's cut herself twice since the occurrence of this incident. So that someone monitoring that would be a good idea. I also thought she should have a psychiatric evaluation to assess for the efficacy of some psychotropic medications like antidepressant medications. So if the court's considering that, then I certainly think those would be helpful interventions in terms of treatment strategies to improve her condition.
Now, my last question, and I want to ask you whether or not it's consistent with what you noticed in a pre-sentence investigation report that was prepared by the court. It noted that Jahara Malik appeared to be in her somewhat disconnected with reality as relates to acting like a child, that she appears the way she acts sometimes does not equal her age level, meaning immature, naive for her stated age. What do you think about that as relates to what you observed?
I think that does describe her. If you'll look back in terms of my report, she reported that with the victim in this case, it was her first relationship. She's 17 years of age, hadn't been involved with anybody else in terms of relationships. Her thinking patterns are somewhat immature, not significantly, but somewhat younger than her age, her stated age. So I'd agree with that, that her thinking and approach to life is somewhat naive.
Thank you so much. I have no other questions.
Any cross for Dr. Brandon?
Yes, Judge. Hi, Dr. Brandon.
Hi, good afternoon.
Okay, so I'd like to just start by looking at the date in which you did your evaluation is July about 2025, right?
Yes, ma'am.
Okay. So at the time and when you did your evaluation, we see here sort of what you reviewed. Essentially, it's the complaint, you had the interview with the defendant, and then meetings with her parents, right?
And I spoke to the therapist.
Right, and then and her therapist, and then on top of sort of, then you did your kind of test yourself.
Yes, ma'am.
Okay. At any time, did defense counsel provide you with school records?
No.
Did defense counsel provide you with any sort of prior history from anyone that wasn't the defendant or her parents?
Her therapist.
Aside from the therapist,
No.
right? And then she presumably was the one who was meeting with the therapist.
Correct.
Okay. So at any point, did you learn that she had actually had other boyfriends before the victim?
No, I didn't know that.
Okay. At any point, were you aware that she had prior instances of aggression between herself and the defendant, or herself, and the victim?
No. I
In
did
which
not.
she, in fact, was the initial aggressor.
I interrupted your question. I'm sorry.
Sorry. Did you have any information with respect to prior incidents of, we'll say, aggression in which she herself was the initial aggressor against the victim?
No, ma'am.
Okay. Were you provided any information with respect to fights that she had gotten in at school?
Yes, one. She said, and her parents confirmed, she was suspended one time for a fight in a situation where she had been bullied.
And is that the fight that happened maybe 2 months before?
I don't know the answer to that.
Okay,
I just
so
know
there was-
I asked about school problems, and that's what they told me.
And that was a suspension. Okay, so there are Miami-Dade school records that were admitted, and I would think the fight is the same. That fight, she articulated and her parents articulated it as bullying.
Yes.
Would your opinion change if... Would your opinion have changed if sort of the circumstances around that fight were not in fact that she was bullied, but in fact that she was the initial aggressor?
So I'm not sure which opinions might change.
So with respect to, I guess, sort of part of your overall examination, if you had learned, because I think, let me kind of take it back, you ultimately kind of conclude that this is partly an isolated incident for her.
Yes, ma'am.
And part of that comes from, you note that there's no reports essentially of like bullying, there's no reports of mental health history, there's no reports of DV, no reports of abuse, no reports of trauma in her life. She otherwise, I think, communicates to you and her parents too that she has this happy, healthy childhood.
Yes, there's an absence of risk factors, yes.
An absence of risk factors.
Yes.
Okay. And so does now learning, I guess, that there are other instances of aggression, right, where she is the initial aggressor, where she is in fact the one who's getting into fights with other people, does that change your ultimate kind of analysis that this could be an isolated incident?
Well, sure, if I was given that information, it wouldn't change my diagnosis or my treatment plan, but if I had competing information, I would have asked her about it.
Right.
And then certainly I wouldn't have given an opinion that it was an isolated incident.
Okay. I want to talk a little bit about 17-year-olds and the brain. And I know that there are a lot of studies out there, and you are regarded as sort of an expert sort of when it comes to this. Is it, when it comes to sort of the brains in juveniles, are all things kind of held equal?
So the progression is equal, but how quickly it moves in that progression, we don't know. So we know everyone's brain about finishes somewhere between 23 and 25. We know female brains grow a little faster than male brains. And we do know that some people move faster than others. But short of an autopsy, we really can't tell who's who. We just know everyone goes in the same stepwise progression.
Is there any impact in that progression that comes from, for example, a healthy home, someone who, for example, we'll talk about we'll talk about a female student gets, good grades in school, is somewhat, the way it's purported, is risk averse, healthy home, nothing, we'll call them red flags, right? Like does that sort of, when we're looking at that hypothetical person, where would that person kind of fall in sort of the risk factor? Or would we not be able to tell unless we get to the autopsy?
No, ma'am, it's a good point. We know nature and nurture. Nature, what you're born with, size of your brain, how those things go, and nurture, what happens that surrounds you. They both impact you. So in the scenario you presented, you'd expect less problems and difficulties and less problems, if you will, or less incidents that would put us here today with that scenario you presented.
Okay, so, and I think you kind of talked about sort of somebody being risk averse, and I want to make sure that I understand, or understanding, I guess, risk. When you talk about that, you're talking about, for example, 17-year-old would be old enough to understand that a knife is sharp.
Yes, of course.
And a knife, it could be a deadly weapon.
Yes.
Okay, so when we consider now the defendant in this case who told detectives that she had a knife with her for protection, that would lead you sort of to believe, and correct me if I'm wrong, that she understood that knives are sharp and knives could be dangerous.
Yes, ma'am.
Okay, and so that in her pulling out a knife in a situation, it could lead to what we would say is something foreseeable, right? Somebody could get hurt.
So if you froze her in time and asked her those questions, yes. The problem isn't in her ability to see that, it's in her ability to control it or put the brakes on it. So she certainly can understand, has the smarts to understand those things. It's just stopping herself from doing that.
And so would it, I guess, repeated conduct, what, if anything, would that tell you?
Well, if there was repeated contact, it would increase the risk. So if you're doing a risk assessment, let's say before this incident happened, and you knew there was repeated incidents, then she'd certainly be in a higher risk range. It wouldn't be an isolated incident.
And so, I guess, is there ever a time where that could fall under somebody otherwise appreciates the risk, understands the risk, but does it anyway?
Sure, that's always a scenario. Sure, but it's still in the same 17-year-old brain that has more trouble with impulse control. So most people are going to control their impulses in that scenario, even though they're 17. Some people aren't, considering the circumstances.
And so when you're talking about the people that aren't, there are obviously people who fall on the side of the spectrum that are, how do we put it, some are better, I guess, than others at assessing risk. So when you're assessing, I guess, somebody who, like, again, we'll go back to the hypothetical person, good grades, otherwise understands risk, has no issues, that person would tend to fall more so on the understands risk and appreciates, that risk.
Well, maybe. I mean, there's other things involved, too, like your exposure to risky situations, too. So it'll give you more of an appreciation. If you're not exposed to risky situations, you sometimes have less experience and less familiarity with it.
And in this case, bear with me.
Sure.
My handwriting, I probably could have been a doctor. When you spoke with the therapist, did she, sorry to transition, but when you spoke with the therapist, did she at any point indicate to you that the defendant had stopped therapy?
So she didn't stop. She wanted to go to monthly. She didn't think it was, she had been going twice a week, then once a week, and then went to monthly, and she didn't think that was a good idea. I told her that she didn't think she could address her emotional distress on a monthly basis.
But the defendant ultimately stopped therapy anyways?
Eventually.
Okay. And then you had said that she experienced symptoms of depression, anxiety, and I think post-traumatic stress. All of those stem, we'll say, post-stabbing.
Yes.
So there was nothing for you that happened, as far as you could tell, before?
No, ma'am. Nothing that was reported by anybody, including her.
Okay. Thank you, Doctor. I have no,
Thank
I
you.
don't think I have any other questions.
Any redirect?
No, Judge.
All right, is Dr. Brennan excused?
Yes, please.
Thank you, Doctor.
Thank you, Your Honor. Thank you for the courtesy today.
Of course. Have a nice afternoon.
You too.
Right. Mr. Handler, do you have any other witnesses that have a time issue? Do you have another doctor, or is Dr. Brennan the only?
Well, let me just check with the doctor, otherwise there's no issue. No, Judge.
So done? Okay. Ms. Rodriguez, who is your next witness?
Judge, for the purposes of downward departure, I think the only other witness that the state would call would be Ms. Harrell, just for the subject to link up for the photo of the text messages. The state does have, as I previously indicated, there are 10, about I think 10 or 11 next of kin who wish to speak to the court, so I'm not sure if Your Honor wants to split that up, but we can.
I think you can put on Ms. Harrell and then proceed to continue with your witnesses, and then I'll have Mr. Hanfield make his presentation.
Okay. I'll use Miss Jean. Mom. I'm going to use Mom. It's okay. And Judge, so for the limited purposes, if you don't mind, I'll just have Miss Jean stand here. Can you please state your name for the record?
Hi, good morning. My name is Nathalie Jean.
Ms. Jean, you're going to be placed under oath.
Please, sir. Please, honest, swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Miss Jean, I'm showing you, or can you spell your name out for the record, just for the court reporting clerks?
It's Nathalie. Middle initial is L. Last name Jean, like Jean Pants.
Can you tell the judge, I know she's going to hear from you later, but who exactly you are and how you're related to the victim in this case?
Okay. I'm Yahkeim Lollar, mother.
I am showing you a screenshot of what has been previously marked and identified as State's Exhibit 1A. Can you tell the court what this is?
This was a text message that was provided to me from one of his classmates. It actually came from the boy that Jahara was dating, and he wanted me to know that he wanted the classmate to show me that she does have a history of that. So they forwarded it to me, and I provided it to the detective.
Okay. And that classmate, what's his name?
The one who sent.
The one who sent it to you, took the screenshot.
Oh, the screenshot was his name was Ted, and then he forwarded it to he gave it to Cece so Cece could know to give it to me, and then I gave it to the detective.
And Cece is the young girl who's sitting back in the courtroom.
Yes.
Okay.
Yes.
And Ted was a previous boyfriend of the defendant?
Yes, ma'am.
And this is a screenshot from his phone?
Yes, ma'am.
Are you familiar with iPhones?
Yes, I am.
Okay. So the blue text messages are who?
Are his iPhone. From him, I'm sorry.
And the gray text messages are from who?
Jahara.
And I think the C up here where it says at the top, crybaby, is that the contact in his phone?
Yeah, that was the contact he had her save under.
Okay. And is this a fair and accurate representation of that text message that you were provided by Cece and that he took a screenshot of?
Yes.
Judge, at this time, the state would seek to introduce what has been previously marked as State's Exhibit 1A as State's Exhibit 1 for the purposes of sentencing. I think the foundation has been sufficiently laid.
Mr. Handel?
Judge, I would be objecting just based upon one, with all due respect, I don't think there has been no verification indicating as that there's a communication that was taking place between my client and this third or fourth person. And so therefore, that's the problem with it. Just based upon the testimony that was just represented right now. And so that's
Okay, we are in a sentencing hearing, so the rules of evidence are lax, and I'll give it whatever weight, but I'm going to overrule the objection and I'll allow it to be admitted for the court's consideration.
Thank you, Judge.
It'll be admitted as part of exhibit.
Thank you.
1.
Judge, I know that there is a doctor waiting, so I do have 10 witnesses, so I'll defer to
He
the
said that
defense.
there was no issue with that.
So at this point, the state is going to call, I lost my list. Sorry, I put my list somewhere. Oh, here we go, sorry. I believe the first person that wants to speak on behalf of the family is Ms. Zelda Bucham.
Good afternoon, Ms. Beecham. Please come forward. You're going to be placed under oath.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do. Good afternoon.
Whenever you're ready, okay?
Yes, ma'am. Good morning, Your Honor. Can everybody hear me clearly? Yes. My name is Zeldrina Beecham. I'm one of 4 of the paternal aunts of Yahkeim Lollar. I'm writing this victim impact statement to express to you how much I have been impacted by Jahara Malik murdering him. Your Honor, I ask that you please be patient with me. This is the toughest thing I have ever had to do in my life. During these court proceedings, as the family, we had to sit there and watch her smirk in the courtroom, show no remorse, and being Yahkeim's aunt, it was really hard for me and for my family. Okay? I remember the day when he was a baby and he came home from the hospital. I took my nephew, Darveed Jr., and my niece, Nathalie Lollar, who are his siblings, to see him. He was the sweetest little baby I have ever seen. I gazed at him as he laid there, as innocent and as sweet as he could be. And there's still a part of me that sees him like that. Yahkeim, as we affectionately call him, Keimo, as we affectionately call him, has always been a bright light in our family. Even during the dark times when we experienced great losses of the people we loved in our family. He was a jokester. He always brought levity to whatever negative situation we had in our family. He was the one that you could always, he gonna make you laugh, no, regardless of the situation. He made me so proud to be his aunt, not just because he was an excellent student athlete, but because he was a very loving and thoughtful and caring type of person. He always thought of others and cared about their well-being, even going out of his way to share clothing and shoes with his friends who were less fortunate. I remember when my auntie Elena had this family function at her house commemorating the life of my deceased mother, who passed away on June 15, 2021. So this was 3 years after her passing. We were at the function celebrating, just in her memory. My brothers were grilling on the charcoal grill, chicken and barbecue ribs, while our favorite music was pumping through the speakers. Some family members were swimming in the backyard pool, others were singing and dancing, just sitting around conversing with each other. We were just creating great family memories. He was there mixing it up with the family and eating and laughing and having a great time. When I was leaving the function, he called out my name. When I turned around, he screamed out to me, telling me goodbye. He had a big smile on his face. I'll never forget that. I was thinking to myself, my nephew is not a baby anymore. He's a growing young man. I smiled back at him, but inside I was crying, knowing that he would have to go out into this cruel, cruel world and create a life for himself. He used to come with his father, who is my brother, and help me put up hurricane shutters at my house whenever a storm was looming. He used to come with his father to help me out in the backyard with my vegetable garden. He was always around to help me with whatever I was doing. The older I get, the loss of that physical assistance that he offered to me is missed. I used to say to him, nephew, when I'm a little old lady sitting on the bus stop in the hot sun, and you drive by in your expensive new car, please pick me up and give me a ride home. And he said, he would laugh and he would say, Auntie, I would never let you sit on the bus stop and not take you home. And that was him. He cared for people. He loved people. Then I would say, okay, baby. He would then smile and continue whatever mischief he was engaging in. Now, because of Jahara Malik's actions, I must go through life knowing that I will never see the full potential of what he could have been in his life. I won't get phone calls from him excitedly telling me things about his future plans for his life. I won't be able to give him advice about whatever's going on in his life. I will never have a chance to see him graduate from high school, college. He wanted to be a stockbroker, and he was on his way. I won't ever see him create a family of his own or accomplish the many milestones of his life that he was going to accomplish because he was just that awesome. He will never be able to go on another camping trip with me. He will never be there again to help me put those heavy hurricane shutters up on my windows whenever we get in a hurricane. I won't have this strong young man and my family to help me lift heavy bags of soil or fertilizers for my garden, which provided nourishment for my family. I will no longer have him to wrap his arms around me and kiss me on my cheek and tell me how much he loves me. As his aunt, I will no longer be able to reach into my bag and place a piece of candy or a $20 bill in his hand so that he could get himself some sweet treats or chicken wings and fries like he liked. I will no longer be able to tell him how proud I am of him, of being the person that he has become, and how much of an asset he is to our family. My son will not have him as a speaker at my funeral. He will not be there to console my son when my life is over. I will no longer be able to look at his fresh new haircut, and tell him that he looks so handsome. And those girls better watch out because he's be standing there smiling and blushing and telling me, oh, Auntie, come on. You're doing too much, Auntie. No longer having him in my life leaves a hole in my heart and a deficit in my life that could never be filled. I'm gingerly moving through this life like I am living in the twilight zone, literally. Because not in my wildest dreams did I think that my nephew, being such the good person that he was, would be murdered like this. This world to me right now is really upside down. In all my years of life, nothing has shaken me to the core like this has. And believe me, I've suffered great losses in my life. I really expected my nephew to be looking down inside of my casket instead of me looking down in his casket. Because of Jahara Malik, I have a skewed view of the world right now. And that didn't do me, I wasn't like that with my 32 years as a police officer with the Miami-Dade Sheriff's Office. Nothing has skewed my view of this life like she has. My 5 siblings and I did not anticipate burying one of our babies. Yet, here we are living this nightmare. Your Honor, it's not fair to us to go through life like this. As a family, we don't even think that 30 years in prison would be enough punishment for her. But we definitely want you to give her the max, Your Honor. I've always honorably upheld law and order, because when I took that oath, I took it to heart. And I served the streets of Miami honorably. Your Honor, I would like to see justice. I would like to see the justice system work in my favor and my family's favor. I have given so much, and I just ask for the maximum, at least for my sacrifices that I've made. Jahara Malik, there are many times in court proceedings, you'll be sitting there smiling and laughing with your family members and showing no remorse for taking my nephew's life. It's not a laughing matter to us. It never has been. It took all we had to stop from jumping across that thing and doing something to you. It will always be a fact that you are a murderer. You are a demon seed that your parents brought into this world to bring suffering on everybody else. Shame on them. When you go to prison, your life will be controlled by the prison guards and the inmates. Your dignity will be taken away from you. You will have to shower and urinate and defecate in front of other inmates. You'll probably get beat up because of your slick mouth and your attitude. There are a myriad of different things that can happen to you in there. And you know what we're going to be doing? We're going to be cheering and saying, yeah, she deserved it. If you want somebody to feel sorry for you or to forgive you for what you have done, get somebody else to do it. Because I will not, and we will not. If you was to go to hell, I wouldn't spit on you to put you out. I hope the thoughts of him screaming for help permeates in that smooth surface brain of yours, and the smell of the blood that you shed from my nephew's young body haunts you while you sleep and while you're wide awake for the rest of your life. Your Honor, I apologize if I offended you, and that's the only person who I care about offending. And if I did that, I really apologize to you for that. I'm telling you, Your Honor, this thing has really devastated me, and I apologize. In closing, I know that the things that y'all had to hear from me wasn't an easy thing to hear, but they are true to my heart and to my core. And I just want to urge you again, Your Honor. I know that the state, is requesting like 20 years plus 10 years probation, but we want to see her get the full sentence, the maximum 30 years. That's what we want, Your Honor, because we really believe that she deserves a whole lot more. There were times we got reports of her going into his classroom, taking his book bag, pouring soda in his book bag, or taking his book bag and throwing it in the hallway, bullying him. And he was taught not to hit girls. And it makes me think maybe we should tell our boys to hit girls back. And he didn't do that, and look at what happened to him. Again, Your Honor, I apologize. I know it's not easy listening to me, but I mean it to my heart. And thank you so much for listening.
Ms. Radisha Jean would like to speak.
Ms. Jean, you're going to be placed under oath.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Yahkeim Lollar was not only a pillar in his community, but also MVP, athlete. He also was my nephew. I just want to say that he holds a special place in our hearts. Sorry, this is hard for me. A special place in our hearts. Words can no longer express the pain or the deep sorrow that we feel about his murder. I hear you guys mention him as a victim. Yahkeim Lollar, victim of love, mistrust, and of course betrayal. Keimo was a math whiz, a loving brother, a young man with a bright and promising future. His life was taken. Keimo was murdered. Our family relives that every single day. His absence has left a void that can never be filled. We will no longer be able to celebrate holidays without feeling that pain and reliving the trauma, especially New Year's, without feeling the loss of the love, the laughter, and the joy that Keimo brings to every one of our lives. Each and every December, we are reminded of the traumatizing moments Jahara Malik put our family through. 5 days before Christmas, she decided to go to his home, his safe place, 5 days before Christmas, and murder him. His kindness, his trusting nature were taken advantage of in a split second.
Sorry,
It's okay. Take your time.
in the most devastating way, this pain of his absence is constant and everlasting. When I look into my niece Treasure's eyes, or Tamia, I instinctively think Keimo's right behind them, expecting to see Keimo beside her for first day pictures or family gatherings. I am met with the pain of having to realize that he's no longer with us. Important milestones that were stolen. I'm so sorry. Important milestones that were stolen that we could have celebrated with Keimo, like his 2026 prom pictures with his classmates. His graduation was stolen from us. The ability to have his first child, or his first drink. The future that he was working so hard towards.
an honor roll student, never had any disciplinary action, never been arrested. Yahkeim Lollar was literally the epitome of a good child. Yes, ma'am. No, ma'am, were the words that you would get from him when you speak with Yahkeim Lollar. He was brought up in a family that way. Yahkeim Lollar deserves justice. Jahara Malik deserves 30 years. The Jean family deserves justice. The Lollar family deserves justice. Yahkeim Lollar deserves justice. The only thing he was a victim of was trusting the wrong individual to come downstairs and open the door for her. Trusting the wrong person, loving the wrong person. When have you ever been in love at 16, 17 and had a relationship that was ended for your life to be taken? As a registered behavior therapist in the state of Florida, self-regulation is important. A parent is supposed to install that in their child. They failed her. And her actions has caused our entire family irreparable pain. Nothing, no amount of money, no amount of time you give her will take the pain away that we all feel when we do not have in our lives. And I'm being completely honest when I tell you this. He was a beautiful, bright soul. His smile light up any room he walked into. And he mattered. Victim this, victim that. The only thing he was a victim of was placing his love and his trust into the wrong, trifling young lady. Not even a young lady, the murderer. Because she is a murderer. Everyone keeps saying stab, stab, stab. She murdered him, cold blood. When someone says no, no means no. The video shows that as well. She deserves the max.
Your Honor, next we're going to have Tammy Leon.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes. Your Honor, Keimo was my godson. As I stand here today carrying a loss that cannot be measured and a pain that will never heal, Keimo, as we affectionately called him, and will forever remember him, was 17 years old, a young black boy that has grown into a young man who we all love, full of dreams and life. That life was tragically stolen from him. His absence is permanent, it is forever. And it does not affect just one person. It has left an entire family, a circle of friends, and a community carrying the unbearable weight of this tragedy. At the age of 17, a person understands the difference between right and wrong. This was not a mistake. This was a decision to take a life that had immeasurable value and deserved to be lived. There must be accountability. We are outraged by this devastating and senseless act, and we are completely broken. I hosted Keimo's 8th grade prom watch, and every time I see his picture from that night, whether it was on the news or social media, it breaks me to the core. Keimo was so fly. Him and another kid that I can't even remember his name right now. And we was calling him Bobby Brown and just having such a great time. All the kids was laughing full of joy and talking about how they was gonna ride for their 12th grade prom. In helicopters, they was already talking about how much fun that they were gonna have, their life and things that they wanted to do after high school. But instead of watching him walk into a senior prom, we are faced with decorating the top of his gravesite. Instead of seeing him put on his cap and gown and walk across the stage to shake the principal's hand to receive his high school diploma that he earned. We will be faced with the pain of making a makeshift graduation, draping his gravesite with his cap and gown and placing his high school diploma on top of it because someone in this courtroom today decided that Keimo's life didn't matter. All of Keimo's dreams are now forever 17. Your Honor, I respectfully ask you to consider the full depth and lasting impact of this loss and impose the maximum sentence. Thank you for your time. Justice for Keimo.
Your Honor, next we'll have Stephanie Harris.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do. Good afternoon, Your Honor. My name is Marie Stephanie Darris, and I am the maternal aunt of Yahkeim Lollar. Thank you for taking the time out to listen to me today. It truly means more than I could put into words. I can still remember the day my older sister Nathalie gave birth to Yahkeim. We were actually in the middle of planning her baby shower. I can remember the excitement and happiness she felt to be having a baby boy. When she called me and said she had gone into labor, I was a little shocked, but nevertheless, my sisters and we all rushed to the hospital to be by her side. When we walked in the room, I remember her just smiling, despite everything, saying, "You have to see how cute he is." In that moment, nothing else mattered. It was pure love, pure happiness, welcoming Yahkeim into this world. My brother-in-law, Darveed, took us down to the NICU to see him. I remember thinking, how adorable is this kid? Even then, there was something special about him. Something you could feel the moment you looked at him. It's moments like that I will never forget. So small, so simple, yet the kind that stay with you forever. Like the first time I seen his smile. That smile, the one I'll never forget. Yahkeim had such a beautiful smile. You know, the kind of smile that made you smile back? Even as he grew up, he kept that same smile. He would run up to me with the biggest smile and always say the same thing, "Hi, Auntie Stephanie," followed by the warmest hug every single time I seen him. Even as he got older, the love never stopped. He was truly a blessing and such a beautiful soul, and that was our Keimo. From the time he was a baby, that was who he was. And I'm honored, as well as my sisters, to have had the privilege of watching him grow into an amazing young man. And I'm so proud to be his auntie. His presence touched not just our family, but everyone around him, as you can see in this courtroom here today. But now our light is gone, and we're left asking why. Why was he taken from us? Every day we are left of trying to make sense of something that will never make sense. We are not grieving only who we lost, but everything he was meant to become. And I want it to be known, I'm not standing here today out of anger. I'm standing here seeking justice for someone who meant the world to all of us. Someone who was deeply loved, someone who mattered and should still be here with us today. And that is why I respectfully ask for the maximum sentence of 30 years. I don't understand that nothing will ever bring Keimo back, but accountability matters. She must be held responsible for her actions. Justice for Yahkeim is more than words. It means ensuring that his life is not overlooked and that the full weight of what was taken from him and from all of us is recognized. A sentence like this affirms that his life had value, that he mattered, and that what happened to him carries real consequence. Also making certain that she carries the weight of what she has done today, not only today, but for the rest of her life. Though the pain of losing Yahkeim will never fully go away, we will continue to honor his legacy. We will cherish his memory and hold on to the love that he gave all of us and the light he brought into our lives. Long live Keimo. He will forever be in our hearts, a life taken too soon. Thank you for your time and allowing me to speak, ma'am.
Your Honor, next we have Casey Beecham, which will be followed by Rachel.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do. Good afternoon. My name is Casey. Keimo's uncle. Ever since Keimo was a little baby, you know, he spent a lot of time with me, my mother, my family, and he was always such a joy to be around. He took an immediate liking to playing football. He played football for the Helping Hands Bulls at Olinda Park. I remember going to the park every Saturday, watching Keimo take that ball from the quarterback, run through the line, and nobody could catch him. I just knew for sure that, you know, Keimo was going, everyone knew that he was going to be somewhere. He was going to be a professional athlete, at very least. Going to Travis Powell to see him play for Miami Northwestern Senior High. Same thing, taking that ball from the quarterback, running it to a touchdown. And today, I'm in a different arena, trying to defend my nephew, defend his honor. I could never, ever believe that I would be here today. But, you know, through the callous and careless actions of an individual that didn't care about anyone but herself, and it's evident in the video. After she stabbed him, what happened? What if he's alive? What if he's dead? What happened? She was thinking about herself. She didn't care about Keimo. I don't believe she took any actions to save his life. The action she could have taken to save his life was leave that kitchen knife in the drawer at home and not take it with you to go see him. I carry a knife for protection. It's not a kitchen knife, it's a pocket knife. And as far as it being a horse playing, I never played that game in school. Never played it on any playgrounds. It wasn't horse play, especially after she said she got mad. That's when the play stopped. They were no longer playing. Keimo was like, "Please, Jahara, stop, don't do it." And she took that knife and she plunged it into his heart. He didn't walk into it. She plunged it into his heart, 4 inches of knife going through his ribs, straight through his heart. I know he suffered. And Your Honor, Keimo, he like it was testified today that he didn't attack her. He didn't do it. I believe that Keimo was not a mean kid. He was a great kid, but he didn't deserve it. But I can tell you this, that Jahara deserved the maximum. Your Honor, right over your head. We who labor here seek only truth. That statement instills truth. It instills faith and fidelity that this court has integrity. And the only truth here today is Jahara meant to kill Keimo. Keimo is dead, and his attacker deserved the maximum 30 years and even more. This is this family's second time in this court asking for justice for someone who killed our family member. My father was killed in 1999, and in the same court we sought justice, and we got justice. Please, Your Honor, I beg you, give us that same measure of justice that my father's killer got in this same court. And I thank you for your time.
Thank you, Mr.
Next is Rajon Darris, then to be followed by Darveed Lollar Jr.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yeah, I do.
Thank you.
Good afternoon, Your Honor. My name is Rajon Darris. I'm here to talk about my cousin Keimo and his impact he had on me and my family. Keimo brought life into people's lives. He respected everyone and never would try to do anything to dishonor you or make you feel uncomfortable. Since my cousin passed, my family has had many regrets. For me, it was wishing I had more time with my cousin. The last time I see him, I said, I'll see you next time I come to Miami. The next time I see my cousin was at his funeral. This loss has changed everything to me. It's broken my family apart. This is a permanent void, and Keimo is a permanent void in my life that can never be replaced. But it's not his fault. His life was taken from him by somebody that had no shit. Birthdays, holidays will never be the same without my cousin. He died the day before my little brother's birthday, 2 days before my uncle's birthday, and 5 days before his father's. Keimo mattered, and his life should be respected. With that being said, I respectfully ask the court to consider the full weight of the loss and impose the maximum penalty. Thank you, Your Honor.
Next, we have Darveed Lollar Jr. to be followed by Sarah.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do. But, I said you excuse my voice, please.
It's okay. Take your time.
Yeah. I can say a lot about my younger brother, you know, more specifically about the day we met, but I won't do that because I don't want to deal with that right now. I can say one day, you know, like I said, my family said he was good at football. I remember one day I had left my own practice and I made an admission to go see his football game because he had one on Friday, which was very unusual for me. And I got there at the later part of the game, and like they said, my brother was a superstar. And when it came to football, nobody came close to him, and I say that with all honesty. I go and I see my brother. His last play of the game, he had the football. You know, he did what he did. He usually scored, but this wasn't just any regular touchdown for him. It was, you know, well for me and him. He did what he did. He scored, but after he scored, I remember him running off and running to the sideline. And I was only there for like 2 minutes. He ran and he jumped in my arms. And that was one of many moments where I felt like it was just us in the world. Nothing else mattered. And from that day forward, from days before that, I just remember him in that moment still being that same baby I saw when I was 4 years old, the first day I met him. And I said that to say, today I stand here carrying a weight that my family has been forced to bear since the day my brother was taken from us. He was only 17 years old, still growing, still learning, still becoming the person he was meant to be. That future was stolen from him and from all of us. My brother will never graduate, never build a career, never have a family of his own. He won't get the chance to laugh at old memories, to make new ones, or to experience the simple moments in life that so many of us take for granted. Every milestone we reach as a family is now marked by his absence. This loss has deeply affected us in many ways that are hard to fully put into words. There's an emptiness in our homes that will never and could never be filled. Holidays, birthdays, and even ordinary days feel incomplete. My brother was the sunshine. He was the sun, not the red sun. He was the complete sun. He could light up any room. He could brighten any day. He can make any sad day a good. He can make any sad day a great one. In my eyes, my brother was perfect, no matter what. In all their eyes, my brother was perfect. My brother wasn't disrespectful. My brother wasn't rude. My brother was kind. Like they said earlier, my brother would give you the shirt off his back. He didn't care if you could fit it or not. You mattered to him. Everyone mattered to him. No matter what you did, you mattered. You were a human to him. And that's all. That's what we asked for you today. I'm sorry. My family has to learn how to live with grief that doesn't go away. It just becomes part of who we are. We are not the same people we were once before. There is a constant reminder that someone we love should still be here, an everlasting yearning for someone who will never come back to us. We stand before you today asking that you grant the maximum penalty, because from now until forevermore, long after her sentence is over, all we can do is speak his name, remember who he was, and honor the life that he should have had. He mattered, he was loved, and he deserved the chance to live his life. That'll be all, Your Honor. Thank you.
Thank you.
Okay, next up, Sierra Harrell. There's going to be a few coming up.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Yes. Thank you.
Dear Jahara Malik, you killed our friend, and there is not a single day that goes by where the truth doesn't press down on our chest. There is no absolute way to dress that up. There is no version of this where damage fades into something smaller. A life was taken. Our friend was taken. And some people who love Keimo is left to carry what you did every single day. We all wake up and remember. We fall asleep and remember. Sometimes it hit us out of nowhere. In the middle of a song, a laugh, a random memory, and suddenly we're all grieving all over again. Our friend should be here. Keimo should be here. He should be living, growing older, graduating with us, going to prom, chasing his dreams, making mistakes, healing, dreaming. Instead, there is a hole where a whole person used to be. A hole that will forever exist because of you. The amount of time that they give you is the number that you deserve. Even though the number might feel abstract to you right now, to us, time stopped the day our friend died. Birthdays, ordinary moments, laughter, that all should still exist. But instead, those were taken. That loss doesn't end with a sentence. It lives on in us. People may talk about that like this is the end of the story. It's not. Their time will be measured in years, in walls, in routines. Our time is measured in absence, in holidays that feel wrong, in conversations that will never happen, in moments where we reach for someone who will never answer again. We are still hurt. We are angry. We are grieving. Someone who should be here isn't because of your actions. That is the truth. Whether you choose to face it or not, grief has changed us, all of us. It has hardened places of us and exhausted parts of us. We have to carry something that we didn't choose, something we cannot put down. I'm saying we because I'm speaking on behalf of all of his friends. I am not writing to comfort you. I am not writing to forgive you. I am writing so that you know that our pain is not silent. I am writing this because our friend mattered, because his life was not disposable, because silence will feel like we're letting him disappear, and we refuse to do that. I hope you sit with what you did, not just the headline, not just the charge, but the human cost. The people left behind, the love that had nowhere to go, the damage that keep echoing long after the moment you made your choice. There is nothing you can do to bring our friend back. Nothing will make this right, but denying the depth of what you caused will only make it worse. So, I just want to let you know that this pain is real. Our friend was real. and that this is proof that he isn't forgotten. And so you know that what you did had weight, consequence, and human cost beyond yourself. You are a murderer. We will carry our grief in our own way, but you will also carry your responsibility in yours. We want the max, respectfully. Thank you.
Your Honor, I'm going to offer a few comments, but I'm also going to call the parents up. They will be speaking next.
They're the last 2 weeks.
Good afternoon, Your Honor. My name is Melba Pearson, and I'm counsel on behalf of the next of kin. As you know, I have spent my career in the courtroom. I have prosecuted homicides. I have evaluated the weight of sentences. And I understand what this moment means, both legally as well as humanly. I am here today not just as Keimo's attorney. I am here because I know this family, and because I believe that what this court does in the next few minutes matters. Not just for them, but as a statement about what we value. Your Honor, you have heard from his aunt, a 32-year law enforcement veteran who devoted her life to this system and is now asking for it to work for her family. You have heard from his classmates, young people who should not yet know this kind of grief, who found the words to say, our friend was real and he mattered. You have heard from aunts, uncles, cousins, and family friends, an entire community of people whose lives have been permanently altered. Each of these statements represents something the law too often reduces to a footnote: the full, irreversible human weight of what was taken. Yahkeim Lollar was 17 years old. He was a gifted student, excellent in mathematics. He was a wide receiver with NFL dreams, and he put in the work to back them up. His mother believed in those dreams so completely that she was preparing to go back to school to learn sports management so that she could be equipped to guide his career. That is not a footnote. That is the story of a mother who saw her son's future and said, I will build myself up to meet it. That is the depth of who Keimo was and the love he inspired. And he did not lose his life to a stranger. He lost it to someone he was in a relationship with, someone he trusted. That dimension of this case cannot be overlooked because it speaks directly to the nature of the harm and the deliberateness of the act. In my years as a prosecutor, I learned that sentencing is one of the few moments the justice system has to speak directly to the value of life. This is that moment. The maximum sentence of 30 years is not vengeance. It is proportionality. It is the court saying clearly, this life had weight. This loss has consequences. And accountability is not negotiable. On behalf of this family and everyone who loved Keimo, I am asking you to impose the maximum sentence. Your Honor, I will now yield to the people who loved him first and the longest. His parents.
All right, Ms. Person, I'm going to wait for Ms. Malik to come back. I think she's using the restroom?
Yes.
I think she needs to be present to hear.
Thank you, Your Honor.
But I will yield my time.
I'm going to take a 10-minute break so that everyone can use the restroom. And we'll be back in court at 3:50.
Your Honor.
All right, we're go.
should Gemini too.
I had to go through with that. Gemini.
It's about 6 little cities in one area.
No, she hasn't had hearings in college, but
this type of stuff. I don't miss his car, but I miss doing the work.
Where you been?
You know when they say it's okay, you know
my granddaughter.
The whole time. It's you. All you see is you. I swear.
seated. Right, Ms. Rodriguez, Mr. Hanfield, are we ready to continue?
Yes, Judge, it's ready.
Your Honor, I believe the family, the parents want to give some.
Of course.
First it'll be Darveed Lollar Senior, followed by Nathalie Jean.
Please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes. Good morning. Your Honor, my name is Darveed Yahkeim Lollar, Senior. Proud father of a gem of a son, Yahkeim Lollar. And before I tell you how the murder of my son affected me, I want to let you know how it affected my other two kids right there. My son like 6'5", my oldest boy like 6'5", like was 280. He lost like 50 pounds in the immediate aftermath. He was, through talks we had, he was, sorry son, contemplating suicide, okay? My daughter, she has chronic sickle cell, all right? And from the day of the funeral for like the following 2 weeks, she was admitted in the hospital, taking breathing treatments, contracted pneumonia, had a self-administering morphine pump. The doctor telling me, watch her, make sure she breathing before you leave. I'm spending nights out there at the hospital, going straight to work the next day. I was really thought I was at risk of losing all my kids, being kidless, okay? All right. It's kind of uncomfortable for me. I'm gonna do what I gotta do for my son. I'm a habitual felon, labeled by the system. This is my first time on this side of the law, but I really want to speak about the injustice that I feel has taken place here. All right. From the night of the arrest, from the night of the incident, nobody informed us nothing about anything. All we know, we were just summoned to the headquarters. We were released and never found out anything else. We had to find out from the street. Charges were never filed. Okay, and I feel like it's a slap in the face to honestly to be 40 days in and they come back with manslaughter. All right, and with all the evidence that we've seen, that they've called us down there to see, medical examiner, the body cam worn video from the scene of the crime, all right, it's just baffling to me how they can take all this time to come up with a manslaughter charge. We feel as though she's been undercharged, all right? We've been seeking the enhancement from the beginning, all right? And you know, they like, the defense would like to call it accountability, all right, saying that she's pleading guilty now, all right? But we think it's being smart because we always been seeking enhancement for the charges, all right? So this is like they're getting ahead of the ball right now, all right? It's 16, 18, a year and a half in, all right? And we supposed to have a phone dump by today's court date, all right? It kind of sounds like water and oil mixing together because, it's over with at this point. You know, for us to get a phone dump today, it probably won't even do us no good, all right? What if it's content in her phone, because kids text each other, they don't talk, you know what I'm saying? What if it's something that she sent a message to her friend saying, I'm gonna F him up? You get what I'm saying? That would have showed premeditation, that would have showed intent, that would have showed a whole lot of things that we could have got these charges upgraded, all right? We've been seeking that from the beginning, all right? We feel like the whole investigation was influenced from the jump. All right, we feel like it was a whole perfect storm for it to happen on the city of Miami side. I'm from a place called Lincolnfield, all right? Everybody probably know it for all the wrong reasons, all right? I've been shot down, AK-47. I done seen people murdered, know a lot of murderers. Don't know anybody that was granted this luxury right here, all right? To be kill someone that night, all right? To be held in custody, taken into interrogation, and released without charge? Like, come on. Now, I feel as though they could have charged her with manslaughter that night if you're going to take all this time to come up with that charge. All right, it was my sister, the police officer, that
added the additional charge that requested through Kevin Bennett Court to add an additional charge of with a deadly weapon, you know, because even before that, she was only eligible to get up to 15 years. All right, because it's a deadly weapon, now it's up to 30. All right, but we shouldn't have to do the prosecutors in the state job. You get what I'm saying? It's more upsetting to me than anything. Yeah, my son gone, he ain't coming back. I'm at peace with that. You get what I'm saying? I don't like the way this case was handled, Your Honor. You know what I'm saying? And then we met with the state attorney, we met with Catherine Fernandez Rundle. The chief of police called us down, we had a meeting with him. I'm quite sure they don't meet with all victims of families of homicide, all right? So it leads me to wonder why, all right? Maybe they know they messed up the case or mishandled the case, all right? It just ain't, nothing makes sense right now at this point. You know what I'm saying? I want to talk about Keimo a little bit because he was the most humblest guy, well respectable. Keimo was so humble. Keimo, I went to pick him up from Charles R. Drew Elementary one day, and his teacher say, hey, in PE, the PE teacher like, hey, the kid's super fast, he jumped super far, and I'm super high, and he's just this super athlete. I'm like, Keimo ain't tell you? At this point, Keimo had won 3 Super Bowls, 3 Super Bowl MVP. Keimo go to school and nobody knows nothing. He was 10 years old at that point, all right? Keimo do not brag on himself. He brag on his daddy, all right? His daddy the best barber, all right? He wouldn't let nobody else cut his hair, all right? Nobody can beat his daddy in basketball if you listen to him, all right? And nobody's better with the bookie if you listen to Keimo. Keimo praises his dad. His dad was his hero, you know? I defend Keimo. I rescue him. I save him. I was robbed that night. I lived 5 walking blocks from Keimo. Walking distance. And that was taken from me that night. So that day, the day of the incident of the murder, I left work early. The graveyard closed at 5 o'clock, 5 p.m. It was my mom's birthday, December 20th. She passed away in 2021. So I called Keimo. I left work early. I get off at 5 o'clock, the graveyard be closed. I called Keimo and invited him to the graveyard this day, you know. I called him and told him I was going to see my mom. They refer to her as Granny. All right? I said, I'm going to see Granny. Keimo, what you doing? He like, I'm playing the PlayStation. And he didn't volunteer to come, so I didn't tell him to put it down and come. I'm giving him his independent 17. I know what he was into. And it was that night that I got that call. I just had invited him to the graveyard. Keimo wasn't hanging around the wrong crowd. It took for somebody he loved and trusted to do him like that. Keimo wasn't no chump. He was a well-respectable young man. He was taught to not be abusive to women. And I think that was that was the reason for his demise. Because I also feel as though if it would have happened, if he would have may have defended himself the first time, because a lot of stuff we found out throughout this whole thing that we did not even know. You get what I'm saying? And I don't understand why these charges, with the stuff that they're telling, with the information that the state was giving us, I just couldn't understand why it's not a second-degree murder charge. And not only that, even if you were to charge us that and convict as a lesser offense, we see this all the time. You get what I'm saying? I don't know why that wasn't applicable in this case. It's just, nothing makes sense with this case, all right? We feel again, like I said, the case was affected from the beginning. The city of Miami, her granddad got the key to the city of Miami, all right? We feel as though if it would have happened on the Metro-Dade side, she would have been in custody that night. You get what I'm saying? It's all what anybody could think anything, but again, man, we just don't understand how it took all this time to come up with the manslaughter charge. With all the evidence and everything that they've told us happened, it is not an isolated incident, what we found out through the state, through y'all. You get what I'm saying? This has happened before. She's pulled the knife on him. She's cut him with a knife before. You get what I'm saying? I can't even bring myself to address her. I don't feel no ill will towards her family. Because I'm quite sure if they knew that she was going to pull some stunt like that, they would have told her, sit your butt down, you stupid girl, you could sit your name. So again, I don't feel no ill will towards her family throughout these whole proceedings. We've made it our business to not threaten, not to address, not to do anything towards her or her family. All we hear is we seeking justice here, all right? And again, it's uncomfortable for me. This is my first time on the side of this law, and I am way out of my element. It doesn't even matter. I'm gonna stand up and honor my son and defend my son. All right? At every chance I get, and I'm sorry, that's it, man. I just wanted to be heard, man. I don't like the way this case was handled. You know, it wasn't no transparency. Nobody talked to us. Ain't nobody said nothing, man. You know what I'm saying? We had to hold rallies and then do all this to get some kind of charges brought. And it's unfair. It's unfair. It's unfair. I don't like it at all. And I'm sorry if I disrespected the court. I don't got nothing else to say.
You did not disrespect the court.
She's already under oath.
Do I need to do it?
No, you're
Okay. Good morning, Your Honor. I do want. Oh, I'm sorry. It's a long day. I do want to thank you for allowing everyone to speak today. So I am going to tell you a little bit more about my son and who he was, and then leave from there. Okay. All right. On September 28th, I was getting my hair done, and I ended up getting contractions. So I'm like, Treya, my stomach hurt. She's like, girl, go to the bathroom. I went to the bathroom. I said, I'm bleeding, Treya. I don't know what to do. I'm just panicking. She was like, oh my God, oh my God. Her mom's a registered nurse. She ran in the bathroom, and mind you, my pants, everything is on the floor, so all my good stuff is showing. So I'm just standing there, and I'm like, oh my God, I don't know what to do. I'm bleeding. I just, Keimo, I hope Yahkeim's okay, because I always told his dad that I loved his middle name. So if we ever had a child, that would be my son's name. So I already had his name prepared. And she was like, all right, we're gonna call the ambulance. So they called the ambulance, they rushed me. They called my doctor in at North Shore Hospital. And when they called my doctor and Mira was having a conversation, she's like, well, Miss Jean, you seem like everything's okay. I don't see anything wrong. I said, but why am I bleeding? Nobody can't tell me why am I bleeding. She was like, well, he's a big kid inside of you. He's already 5 pounds, so it wouldn't hurt to take him out early. Because Keimo's original birthday was November 3rd. Like that. So she was like, I said, well, you're the doctor. What would you do? She was like, take him out. So they prepared me for emergency C-section that day. So we ended up going to the emergency room, and my mom and my sisters and dad came, because you know I'm the big sister, so everybody's rallying around me, and I'm just got my head down. I'm praying. They talking, but I'm praying the whole time. All I'm saying is, God, let my baby be okay. And then we went into surgery, and he came out. The pediatric doctor said, he's gonna need a blood transfusion. I said, okay, no problem, but I don't hear him crying. Before you take my baby, I wanna hear him crying. I need to make sure he's okay. She was like, but he's okay. I said, no. I need to hear my baby. But you could take him after that. So Keimo started to cry, and they left. And that always stuck with me and stuff. So fast forward, I think he was like 3 or 4. We was coming from Winn-Dixie, and they have the blood drive trucks outside. And the lady came, she's like, hey, would you like to give out blood today? I said, sure. I said, let me drop my groceries and I'm gonna go. And Keimo was like, hey, you know, he's just always bouncing everywhere and everything. And he's like, Mom, what is that? I said, I'm gonna tell you why I'm doing it. He's like, huh? So he's looking at me as we go in there. I said, you know, someone saved your life. So that's why today I choose to give blood. When you get older, I want you to do the same thing. Because if that person didn't donate blood for you, you wouldn't be here today. And he was like, with his little eyes, you know, he has the most adorable eyes and a beautiful smile. Okay, mommy, no problem. Fast forward to high school. I'm in my room, cleaning up. I just hear my door go boom. I'm like, oh, here he go. Then he comes in, he's like, Ma. And he bounces just like this in my room. Ma, guess what I did today? I'm like, what, Keimo? What did you do today? He's like, I gave blood. I remember when you told me that, so I gave blood today. I said, that's what I'm talking about, boy. I know that's right. He was like, I got 2 pizzas and a movie ticket, but I did, but I gave it today. That's the type of person my son is. You see, he remembered that from 3 years old. He remembered that conversation. He remembered somebody saved his life, so he was willing to save somebody else's life. So this is why it's hurting everybody out here. See, the difference is that someone was able to save my son's life by giving out blood, but that night that Jahara took my son's life, nobody could have saved his life. Nobody. It was nothing they could do. She gave my son a death sentence. It was nothing nobody could do for my son. I find myself like just dreaming about how I took him to his first football practice and he's crying and whining. And I'm like, oh, you got to stick this out. You told me you want to play football? You're going to play football. You got me coming out of here and you told me you finna cry? No, we're going to stick. I remember running inside. I started from saying, go, Keimo, go. Run, Keimo, go. Take off, Keimo, take off. That's how I started. I'm one of those parents who's running aside the sideline with their kid, screaming out his name all the time. Imagine watching your son grow to be the person that you want them to be, and you getting them ready for the future. You're preparing your son, because if you have kids and if you have a son, especially a brown son or a black son, you teach your kids how to conduct themselves out here when you're not. I always tell my kids, you are a representation of me. So you carry yourself as such. You understand what I'm saying? My son is yes ma'am, no ma'am, yes sir, no sir. You will meet my son one day and you'll remember him for the rest of your life. She took that away. The night of, it was a regular day in our house. We was putting up the Christmas tree, me and Treasure, my youngest. He came in the living room, the first thing he said, because he's always a jokester, pink tree, huh, Mom? Pink tree. I said, boy, you better ask your sister, which is my oldest, Tamia. She waited the last minute to get that Christmas tree, so we got to get what we getting. And we all was in there doing the tree. And for some reason, it's just like it wasn't coexistent or whatever. It was just a beautiful day. Tamia was she was coming in the door, and he was coming in out of his room, and we was playing music. And we was just like, it was just our song, and we was dancing. We was listening to Mariah Carey, We Belong Together. And then he just coming out the room and he's just singing. He's like, when you left, I lost a part of me. And he just singing his heart out. And then we in the background, we his little cheerleader, we like, we belong together. And we just singing. And then it was just, that's our normal routine. You know what I'm saying? It was just a beautiful day. Never would we imagine that. We ate, he went in his room. I said, oh, hey, Jib, the trash. He told me, all right, Mom. I said, no, your room. He was like, oh, okay. I said, I'm off tonight, so I'm going to be here. He said, Mom, I promise I'm going to do everything in the morning. That was the last thing my son told me when I went in my room. Mom, I promise I'm going to do everything in the morning. Then I got that phone call. Not from police officers or nothing. One of his classmates called me and said, Mom, something happened to Keimo. You need to go to the hospital. Then somebody texted me, Jahara stabbed Keimo. But her lawyer wanted to say she reached out to me. When she wanted to talk to me about other stuff and communicate, she know my number. But she didn't know it that night. Well, her mind was a fog that night. But when we talk on a regular, she knows my number. And then an officer, as I'm on the scene, tells me, Miss Jean, yes. Is Yahkeim Lollar your son? Yes. I'm sorry to tell you, he didn't make it. Why? I'm just getting on the phone with my dad to explain to him what's going on, but I don't know what's going on. I turned into a little girl that night. Could you imagine calling out for your dad? I'm like, Daddy! Daddy! Yo, tu es petit moi! Petit moi mourir! That's what I'm saying. I said, my child is dead. They told me they killed my child. That's what I said to my dad. I turned into a little girl that night. And then have to get that phone call. I have to tell his dad that his son no longer here. My daughter called me. She was like, Mom, I don't understand. I'm at the hospital. They're saying he's not here. I got to break that down to her, letting her know that her little brother that she helped me raise is gone. Imagine everyone calling you that night to find out what's going on with your son. And when you tell them that your son passed away, they hang up on you. From that night all the way to the morning, that's what happened to me, Your Honor. Because nobody couldn't believe Keimo, out of everybody, Keimo, who don't bother nobody, that's the only way she would be able to kill him, is at home, because he doesn't go anywhere. The only way Keimo going somewhere if he know it's food there. That's the only way. Imagine that. Imagine going through all that. And you still got to be a mom. You still got to be strong. You still got to make sure everything goes right so you can send your baby away. You got to sign papers. You got to do this. You got to do that. You know how I had to identify my baby? With a goddamn picture. That's how I had to identify my son, by a picture. And he died with his eyes closed and his mouth open like he was shocked. He was in disbelief. Imagine going through that. Imagine going through all that. Imagine picking out your child casket. Right? Because he's supposed to do that for me. I'm not supposed to do that for him. Imagine doing that. It took them 4 days to release my baby body. 4 days. The funeral home called me and said, Nathalie, I just got his body. Are you sure you want to see him like that? I said, that's my baby. They told me he died. I got to see it for myself. 4 days don't went past. Everybody told me he dead, but you got to see it to believe it. When I went to go see my baby, he was unrecognizable. His skin already melted. His skull was here. The only thing you seen, no defense wound or anything, was that gash around his chest where she stabbed him. And through all that ugly, Your Honor, through all that ugly, you still could see that beautiful smile. Through all that. Through all that, Your Honor. And then you have to prepare to send your child to go home. You know how hard that is to see your child? It's different to see your child in a box. It's totally different. I can't even tell you what was said at the funeral. All I remember she said was, Mom, one last time. Then I had to stand there, me, his dad, and my dad, and close my son's casket. And when that door went down, I went down with it. It went down again, and I went down with it. It went down, and I went down again, because I had to see it all the way through. Then I heard, click. And my whole world just stopped. When I got to that cemetery, every emotion that I've been holding on and trying to keep strong and all that came out at that cemetery. Because now you're really seeing that it's true. It's really true. And I said, Keimo, you trying to tell me you left me? You left me? Keimo, you left me? So you saying that my son not here today because he chose not to be with somebody? My son lost his life because he chose peace? She took that knife, stabbed him in the chest and pierced his heart, and my son bled out. She called me on December 12th and said my son broke up with her. 8 days later, she killed my son, but she want me to believe they was horse playing. Because that's what they're saying. And through this whole proceeding, and while we crying and going through stuff, her family back here just laughing and like brushing us off like we don't have no feelings and like we're nobody, like we're not valid, that we want justice. Because had my son did that to her, it would have been totally different, right? Totally different. Through this whole proceeding, she never showed remorse. She never showed she cared. You can even look at the news clip. Not one time she showed that she cared. She actually showed that she'll do it again, to me. But it's horse playing. Your Honor, I'm asking for the max. My son deserved it. She earned that max when she pulled out that knife and stabbed my son in the chest and pierced his heart. Imagine this, Your Honor, being your normal conversation from now and forever. Dang, if Keimo was here. Dang, y'all remember when Keimo did this? You forgot how Keimo used to laugh? Oh man, I wish Keimo was here. Dang, I'm not gonna lie, I miss Keimo. That's our reality now, Your Honor, now and forever. So all we asking for the max, we believe she deserved more than that. The justice system been failing us since day one, Your Honor. And I hope today you serve justice. I hope today you show why you sit on that bench and wear that robe. Right is right, wrong is wrong. She was wrong. If she never pulled out that knife, my son would be here and we wouldn't be sitting facing each other today, Your Honor. We just want what my son deserves. His life matters. I do not want to leave here today, Your Honor, feeling like I lost my son all over again, Your Honor. Thank you for listening to me and my family. I hope today you got a sense of Keimo, who Keimo was, and I hope you see when you look out there how much he was loved, Your Honor. Thank you.
Judge Christine has no further witnesses to be arrested at this point.
Mr. Enfield?
Judge, I will be calling at this time Dr. Safe.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? I do. Thank you. Allison.
Mr. Enfield, you can proceed when you're ready.
May it please the court. Good afternoon. Dr.
Good
Safe.
afternoon.
Will you identify yourself for the record and spell your last name, please?
My name is Lindsay M. Sy. Sy is spelled S-Y-E-H.
And what do you do for a living now?
I'm a licensed mental health counselor.
And how long you been doing that type of work?
I've been doing it for 5 years.
And in doing that type of work, tell the court exactly what is it that you do, as far as letting us know what is as part of your work, what exactly does that entail?
As a licensed mental health counselor, I see clients in an individual setting with couples and families. I also host workshops in the community that talk about mental health as well as forensic mental health assessments. I diagnose and treat mental health disorders.
Did you, in your capacity, ever come in contact with Jahara Malik?
Yes.
And can you tell the court when that was?
The first time I came in contact with Jahara Malik was when I had outreach from your office that invited me to be a part of her case, and I saw her in February of 2026 as a client.
And did there come a point in time that you had an opportunity to conduct an evaluation of her?
In February, I conducted an evaluation, and that's called a forensic mental health. It's a part of that report where we do a clinical assessment, we do a clinical interview, and then write up a clinical report.
And can you walk me through, tell the court exactly what you learned and what you were able to assess, first starting off with what was your assessment, if any?
Absolutely. And so I did about 7 assessments with Jahara. The first one I did was an MMPI-3.
And what is that?
An MMPI-3, it tests for psychopathy in clients that are 18 plus years old. And it has a battery of questions that have 7 domains. And it is a series of depression, suicidality. It talks about trauma. Those are some of the things that were assessed in that assessment. Another one was the Beck Depression Inventory. And so that assessed depression within 2 weeks of seeing her, or depression symptoms that she may have exhibited within 2 weeks of me seeing her. I also did a Beck's Anxiety Inventory, the same, but this time it's symptoms of anxiety. I also did a Beck's Hopelessness Scale, and it assesses the severity of depression to the extreme of hopelessness. I did a Miller Forensic Assessment and Symptoms Test, and so that is an MFAS. It assesses the malingering, and so whether or not a person is feigning their testimony or their symptoms, it helps me to assess that, as well as a reliable digit scan, and so it helps with the validity of everything that she is saying. You're doing back and forth with just giving her numbers, just a recitation to see if cognitively, if she is aware. And then last but not least, I did a mental status exam.
All right. For those of us who are not as have the same knowledge that you have, let's break this down in layman's understanding. As relates to the first testing that you did, what were you looking for and what were your findings?
So what I was looking for in the first test were just how she presented with her personality. And what that came up, the results were that through the 7 scales, we looked at the hopelessness and helplessness, the anxiety-related experiences, the suicidal death ideations, ideas of persecution or apparent experiences. And at the end of that, it just concluded just this profile of how she showed up and how she responded to the inquiries that the test provided.
And why was that important for you to know?
It's important for me to know because it assesses behavior, it assesses how she's showing up with maybe her cognitions, her thoughts, her feelings, her state of mind, and whether or not it's consistent with the observations that I would make through the mental status exam, if they would be congruent to what she's being assessed for.
And what did you learn as relates to the first test?
So what I learned that her numbers for helplessness and hopelessness, it was very high. I also learned that she presented...
When you say high, in layman terms, what does that mean?
So the score that one would get is about 65. She landed at 80 for the helplessness and hopelessness. For anxiety-related experiences, again, 65 is the baseline, but she rated at a 69. Ideas of persecution and apparent experiences in substance abuse, she rated at an 81, an 83, and a 75.
So what did that tell you, and what conclusion were you able to reach any as relates to that first?
Based off this, it showed me that she presented with symptoms of depression, she presented with symptoms of suicidality, she presented with symptoms that exhibited anxiety as well, symptoms that just painted a picture of how she felt about the thoughts that entertained with maybe persecution, apparent experiences. That's what it told me, that these were the symptoms that she had.
Did you get an opportunity to go over and review and understand exactly what happened on the date of the stabbing that she that you learned that she was responsible for. How would you address the court on the issue of her being, whether she was remorseful? What were you able to gather and learn from that?
So when we went and sat for our clinical interview, I wanted to just understand some context of what happened. It's typical to understand the context, and then we went through systematically her history of childhood. We talked through her school history, any history with drug and alcohol abuse, any history about how she lived socially. And so we landed at the end talking about just remorse. You know, how does she show up with her understanding of what happened? And at the end, she showed that she was remorseful for the incident that happened, and it was as evident as her self-report.
Now, you said suicidal. Did you have any concerns as it relates to suicidal thoughts or relating to what you were looking for?
I had concerns about it, and I did a suicide risk assessment in the session, and she declined thoughts of suicide presently and thoughts of intentions of wanting to harm herself. But she also stated that those were ideations that were ever present, but in the moment, she denied that that was happening.
When you were speaking to her?
When I was speaking to her.
But you said there was she was able to communicate with you that there were some concerns about suicide.
Yes.
What else did you learn?
I also learned that in talking with her, if I can just refer to my report.
Sure, go ahead.
So I also learned about her is that she was very a studious student. She told me about how she went to school and how she hoped to aspire to become a nurse one day. She told me about how she envisioned going to college and wanting to connect what she wanted to do in college, her major in nursing, to one day to become a beautician.
Now, after you completed your evaluation of her and your assessment, did you reach any conclusions and recommendation for consideration should be taken by the court as relates to this particular case?
So based on the conversation that we had, the interview that we had, there were some conclusions that I reached. One, a recommendation to the courts for trauma-informed mental health treatment. This was recommended because the examining, just their symptoms of, just emotional regulation, how to manage stress. I also recommended that there be restorative justice informed programming, if applicable. And so what this does is that, as they work to support them in accountability, reflection, empathy, and community reintegration, I recommended as well, I did life skills and decision making. And so this would be, structured life skills developmental programs is recommended to help with the judgment, conflict resolution, and personal safety awareness. These are some of the recommendations that I made. As well as structured rehabilitation program with aftercare. There was also a recommendation for family support and counseling.
Now, did you, during the time period that you had an opportunity to evaluate Jahara Malik, you said that she came across remorseful. Did she ever communicate with you as it relates to her position as far as accepting responsibility and regretting what happened that day?
Towards the end, or at the top of the interview and towards the end, I asked questions about remorsefulness, and she did express remorsefulness for what happened. She stated that while she was on the scene that, you know, she did her best to help and to support and to aid in care, and that, you know, she was very sorry and for what had happened.
Now, did there come a point in time, I'm going to go to conclusions. I know that you gave some recommendations as it relates to, for the court to consider. First of all, let's talk about the age at the time of this incident was 17 years old, right?
Yes.
And no prior contact with the criminal justice system. Now, what is the significance, if any, as relates to the 17 years of age?
So when we look at 17 years age, they're almost at the tail end of their teenage years, and so 18, 19 marks that end. And what was significant for me was that, you know, her brain is being developed and it's in process of development. And so as I thought about that and processing this with her, it was more so about, you know, decision-making, impulse control, emotional regulation, everything that entails that, and how she developed those coping skills from early childhood. How was it being reflected in the present? So I was conscious of that.
And what was your, as relates to recommendation for the court to consider as relates to this particular case?
So my recommendation pertaining to this case would definitely be in alignment with trauma-informed mental health treatment, the restorative justice-informed programming, the life skills and decision-making education, a structured rehabilitation program with some form of aftercare treatment, and family support and counseling.
Are you familiar with the Miami-Dade County Boot Camp program?
I've heard of it.
Okay. And upon learning some of the benefits of it, as it relates to this particular case, what were your recommendation to the court pertaining to programs like that?
Well, from what I know, boot camp has an opportunity to instill some of the aforementioned recommendations that I have. It can integrate trauma-informed mental health treatment, restorative justice-informed programming, life skills and decision-making, and, you know, definitely structured rehabilitation.
Now, you had an opportunity to listen to Dr. Brennan as it relates to his evaluation as relates to Jahara Malik, right?
Yes.
And there is one thing that I brought up, and that is one of the things he did, he wanted to, with all of his years of experience, to test and see whether or not the person was, as we call it, gaming the system. And he said he tested that and he determined that that was not the case. Do you join in and agree with Dr. Brennan's assessment based upon what you had an opportunity to assess and see for yourself?
So I did a test called the Miller Forensic Assessment of Symptoms, and this test, it tests for malingering and feigning. And so when I tested Jahara for it, she scored out of 4, and it established this cutoff for malingering, which indicates there's no significant evidence that the client was exaggerating or fabricating any symptoms.
So would it be your opinion that she was, one, remorseful for based upon what happened, that she was sad, that she wanted to accept full responsibility based upon what happened?
Based off my observations in her self-report in our session, she exhibited remorse, regret, and, you know, she had sadness in the session.
I have no other questions, Your Honor.
Thank you, Mr. Fairfield. Any cross?
Yes, Judge. Hi, doctor. Can you remind me how to pronounce your last name? I don't want to.
Sai.
Sai. Okay. So you met with the defendant February 4th, 2026. How long were you with her?
I was with her about 3 hours.
And that is the total of your time with her?
No.
No? How long were you with her overall?
So I would say about 4 hours.
4 hours total.
Mm-hmm.
And that is where, and after those 4 hours is essentially what's in your report?
Yes.
You didn't meet with her any other time?
No.
Okay. So during your meeting with her, you have here as sources of information and evaluation procedures. What you outline are Miami-Dade Police Department lead report, complaint, arrest affidavit, and work product. And you did your testing as you described, and then you did a clinical interview. That is all that you used, of course, over the course, of the 4 hours that you were with her in making your assessment.
Yes.
Okay. So during that time, were you provided any history, any Miami-Dade school records?
Only based on the counselor and the client's self-report.
Self-reporting, okay. Were you provided any reports from any pediatricians or any doctors' notes with respect to any mental health prior diagnoses?
Only based on the client's self-report.
Were you provided any sort of outside material other than, right, the client's reporting? No, okay. So in your ultimate assessment, she self-reports, and I think what you end up noting is ultimately she has a happy childhood, right?
Yes.
There's no history of domestic violence within her home, right?
That wasn't reported to me.
There's no trauma in her home, nothing reported. There's no history of abuse on her, that wasn't reported. At no time did she ever tell you that there was any history of violence on behalf of the victim in this case against her.
No.
No, okay. At no point were you ever provided any information about prior instances of aggression between her and the victim where she was her and the victim where she was the initial aggressor?
No.
Okay. I want to talk about the test that you described, and I apologize, I don't remember the name, but where you determined sort of malingering. If I noted in your report that you noted that she, the examinee describes herself as sort of the good girl that works hard in school, you know, and she sort of denies her involvement in, you know, extracurricular activities and you know, and essentially it's all self-reporting. So if she believes, right, that she's essentially a good girl, right, a kid who otherwise behaves, does your test sort of account for that? Like that would, to you, it would signal she wasn't malingering?
What I would do is just, I look at, through observation, how she's reporting.
Okay.
And so the test just, it asks questions that's based off of like, how does she present with like suicidal ideation? How is she presenting with symptoms of anxiety and depression? It doesn't specifically just say only behavior, but thoughts.
But thoughts, okay. So, but in making your assessment, right, as to whether or not somebody's being completely forthcoming with you, if someone really believes, and I'll use a hypothetical, so if I'm the one who's talking to you, right, and whether, let's say for the sake of the hypothetical, I'm a bad person, right? But I go in there and I tell you, I'm a good person. Like I believe that I'm a good person. I believe that I always follow the rules. Are you able to, through your test, assess, right, whether I'm just being truthful? Like if I just believe it, regardless of what sort of the facts and precedents say, can you tell that?
Well, there can be a belief, but then there has to be also congruence with what is the affect saying, what is the thought cognition saying. So I'm actively doing a mental status exam to see the congruence between what someone is saying to me versus how they're saying, versus how I'm observing what they're saying.
So essentially, if somebody, whether they believe it, but then they're able to, with their affect, and they're able with their affect to sort of convey that, they could otherwise pass.
Repeat that, please.
So if somebody believes, right, that they're the good, I believe, we'll use my hypothetical, I believe it, but then with my affect, I can otherwise present that it's sort of in line with me thinking that I'm a good girl. Could they otherwise pass when maybe they are maybe fabricating something to you?
I mean, I'm looking at the context from start to finish.
Okay. So essentially what it comes down to is everything in your report comes down to her self-reporting and her version of the events.
And based on what I'm reading in the reports that I got as well.
Okay, and the reports of the police department and that, okay. Okay, so now I want to talk about when we look at sort of the brain. We've gone through we've looked at your report, right? You have someone who, you said no DV, no abuse, otherwise happy childhood. You had nothing from school, so as far as she's reporting, no issues at school, there's no IEP. She's otherwise a good kid, good grades, right, that she gets. So now, we're taking a person sort of with that, and now we're talking about impulse control, right? So when we look at, the human brain, just because somebody is, the human brain sort of doesn't develop until 24, does that mean that someone would not be able to appreciate, let's say, the dangers of a knife?
Can you please restate your question?
Okay, so we're taking everything right in the context of sort of the evaluation that you did, right? And the person that you're looking at with good grades, sort of all that, right? So now we're talking about the brain developing. Brain develops, like you said, between 17 and 24. 17 is on the lower end, 24 is on the higher end. So when we're talking about sort of the development of the brain, just because somebody is 17, we'll start there, does that mean that they therefore could not appreciate the danger of a knife?
I mean, at 17, when you say appreciate, what do you mean with appreciate?
Okay, so that a knife is sharp, that a knife could hurt someone. Right. So they still could.
Absolutely.
Okay, and so when we look at your report, right, I'm particular on page 5. One of the things that is noted, right, is it says respectively, when we're talking about trauma and impulse control, and you can correct me if I'm misunderstanding it, but it says that when you're looking at your test, it recognizes that trauma exposure, emotional disturbance, adverse life experiences are relevant considerations because of the potential impact on judgment, impulse control, and decision making under stress. Okay, so now we take into context, right, someone who's smart, right, good home, no trauma, no reported emotional disturbance, no adverse life experiences, nothing really that is, we'll call it a red flag, right? And now sort of the question is, how does impulse control affect that person? It seems like it would be less likely, right, to affect that person versus somebody who did have all those red flags.
Right.
Is that accurate?
Well, what I'll say is this, environment can also play a part in it as well.
Okay.
And so when I observed and when we had our clinical interview, those were things that I took into consideration when writing the report.
Okay, and so for when we're looking at Ms. Malik, I mean, did you ever at any point ask her whether or not she knew that knives were dangerous? I
asked her about just violence in general and her understanding of violence.
And did she understand it?
Yes.
Did your sort of analysis incorporate the fact that she had a knife? She tells police she had a knife for protection.
Yes.
And so protection, right, would mean that she would use it to ultimately defend herself against anyone who came at her.
Yes.
So would that tell you that she understood that a knife could be used in order to, let's say, save her life or endanger somebody else?
Yes.
Right? Okay. So would it be a fair assessment to say that she understood that knives were dangerous and that they could cause harm?
Yes.
Okay. I have no further questions. Thank you.
Any redirects?
Just one question, I think. Well, I guess I need to go to the mic. I'd like to say one question, and I want to keep it very simple. Is there a correlation between the age of 17 and someone 17 participating in risk behavior, horse playing with a knife, age 17 versus someone 24 or 25 doing the same thing? You see the difference? Meaning, one of the things you discussed, and Dr. Brennan, that there is certain risk behavior associated with the age 17. Is that correct?
Yes.
That would not be the case when you're dealing with someone at the age of 24 or 25, because the brain has fully developed. Would that be correct under that scenario?
What I would say is this, it depends on circumstances.
But their risk behavior is something that is more associated with someone that's young, such as a teenager at the age of 17. Is that correct?
Yes.
Okay, thank you. Nothing further.
Is the doctor excused, Mr.
Yes,
Mayor?
ma'am.
All right, thank you, Dr. Singh. All right, Mr. Hanfield, do you have any other witnesses?
Yes, Judge. These will be quick character witnesses. First person will be Terry Wright.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole
All
truth,
right,
and nothing but
everyone
the
needs
truth?
to be quiet.
I do.
Would you state your name for the record, please?
Terry Wright.
And you identify yourself as far as what you do for a living?
I'm the CEO of Writing Young Funeral Home here in Miami.
And will you state to the court why you're here today?
I'm here to speak as a character witness for Miss Malik.
And what would you like the court to know about as linked to Miss Jahara Malik, sir?
Well, I've been knowing the family for over 40 years. They have a business here that I've been a customer for the last 30 years. Being said that, if I may just tell a story, there was a young man by the name of King Carter, 6 years old, that was killed exactly 10 years ago here, 6 years old. And we started a nonprofit called Don't Take My Life, Let Me Live. 10 years ago, Ms. Malik was only, today, maybe 10 years old. But back then, we started with different rallies to promote violence and don't take something you can't give. With that being said, we had t-shirts that me and her godfather gave away free, and I remember her vividly wearing that little t-shirt when she was a young little lady, serving the community at the shop. Didn't know no better, but you know, when we have businesses, we try to train our families to one day become either entrepreneur or take over the family business. With that being said, as years passed by, as I would frequently visit the store, that she would be there. So we only have our character, and I only could speak about the character. I can't speak about this case. My heart is very troubled today because I'm burying young people in and out. And these families are destroyed today. And situation arises in our lives. And when it comes to lives, we all must treasure lives. And we must think about our hearts. When people greet you and when people assess you, you begin to know people. Because Maya Angelou once wrote a poem, she said, when people show you who they are, believe it. And all I could do is attest to her being at the store with the pleasant attitude serving. It's traumatic today for these families to be at this gesture. And I pray God will mend hearts in some kind of way. And it's my prayer today that as we leave this courthouse, and as time comes, and time will come, days and years will come, that hearts will be mended. We will never forget our loved ones. Never forget our loved ones, because it's a treasure to us. But we must also learn that life is about forgiveness as well. It may not happen today or tomorrow, but all we have in life. And with that being said, I pray as I go out this courtroom that God would touch hearts in here today in a very special way.
Thank you. The next person is Shawnette Davis.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Will you state your name for the record, please?
My name is Shanetta Davis.
And what do you do for a living?
I am a corrections officer,
Where?
Palm Beach County Sheriff's Office.
And what would you like to address the court?
Greetings, Your Honor. Judge Hernandez and all parties present today. I recognize that this is an incredibly difficult moment and one filled with deep pain. To the victim's family, I want to express my deepest condolences, and I truly am sorry for your loss. I have known Jahara for all her life, and she is like a niece to me. I've watched her grow into a loving, compassionate, intelligent young lady. She is deeply family-oriented and has shown a desire to build a positive and meaningful future to become a registered nurse. Throughout this period, Jahara has taken responsibility for her actions by pleading guilty, which demonstrates accountability and remorse to me. In my professional experience as a correction officer, I have seen firsthand that juveniles and young adults are still in a critical developmental stage. I respectfully ask the court to consider leniency in her sentencing. Thank you, Your Honor, for allowing me to speak and to be heard.
Thank you. Ted McCray.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Would you state your name for the record, please?
My name is Theodore McCray, Ted McCray. I am a pastor and a former teacher at Miami Northwestern.
What would you like the court to hear from you today?
Your Honor, I just want to speak from the heart today. I just want to talk for a moment because today I saw something. I saw the fact that nobody wins. Nobody wins in a situation like this. It affects and effects everyone that is involved. Today, I remember I retired from Northwestern, so I was over there 20 years. And most of you students who are here, and I know you. I know you just as much as your mom and them know you almost. You spent hours out the day with me. And everybody knows how I operate. I'm not just Mr. McCray. I'm Uncle McCray. I'm Dad McCray. I'm there always. When you're hungry, yo, McCray, you got some snacks? Yo, hook me up. And I do just that. But it's not about me today. It's about the maturity of this situation. This is a situation that we need to grow from. Jahara has to take responsibility, and also we as listeners have to take a certain responsibility as well. We're all in this together. It's important that we grow from this. I see this. Yo, I want you all to know that, listen, nobody is perfect. Nobody does all the right things. But there's a level of accountability that has to be reconciled with. We have to take that into consideration. That these things happen, especially with children. They need to know that to whom much is given, much is required. They're blessed. All of you are blessed. And I just wanted to come and let you all know that this is not a time to take sides. This is a time for you to look at yourself. See what you got going on. How grown are you? Where is the adult that's supposed to be in you? I listened today. I heard some stuff. Some things I thought was good, and some things I thought was not that good. Things were said in here. and I saw hurt where there needs to be healing. We need to come together in our own self. You know, there's a saying, say, how you gonna throw, rocks at my house when the house you live in is made of glass? So listen, Jahara, there's love for you, baby. Mommy, you said some things that I thought was important today. You expressed to us how you really felt about Keith. I know them. They was all freshmen and juniors, freshmen and sophomores when I retired. I know them. They used to come by my class. I know all the boys, don't I? Yeah, you know I do. If you went to Northwestern, you know me. Mr. McCray, the man who taught cosmetology. All the girls was in my class, so I know you stopped by. Listen, it's not about that. It's all about your future. So please, take a look at yourself before you look at other people.
Thank you. Angela Powell.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Quietly, will you identify yourself for the record, please?
My name is Pastor Angela Powell Williams.
What would you like the court to hear?
I would like the court to hear a character witness for Jahara Malik. First, Your Honor, I would like to thank you for allowing me to speak today, and if I could, I would like to offer my condolences to Yahkeim's family. First, I would like to acknowledge, as a woman of God, and most a mother, I recognize the depth of your pain for the loss of your son, your brother, your nephew, your friend, and your best friend. There are no words left to fill the void in your hearts, but I offer my condolences, my deepest condolences, and continuous prayers for your family. I stand before this court today with sincere reverence for your grief. I have known Jahara and her family for many years, inside and outside of the community, and I just would like to say in no way do they celebrate or they're against you in any way in this matter. Their hearts are broken, and if they could do anything, they would fix this. Since this tragedy occurred, I have served as a one-on-one spiritual mentor for Jahara through private sessions, prayer, counsel, and guidance. In the time I've spent with Jahara, I have seen her face the gravity of her actions. She does not avoid the truth of what happened. I have sat with her in quiet moments where there were no cameras, no social media, and I can tell this court today she is deeply broken by this tragedy, not just her family. Her guilty plea is a reflection of her accountability. We have worked together for hours. She understands the weight of her hurt. She has caused this family and the gravity of her actions. What I have observed in our sessions as her mentor, her spiritual guidance, is a young woman who realizes she cannot move forward without guidance. She has learned that it is okay to ask for help and to seek a better path. She shows humility and genuine desire to be a different person than that day. I once asked her in our sessions, if you could change anything, what would it be? And she said, that entire day. I am personally committed to Jahara, continued mentorship, I believe she has a heart that can be molded to good. My role is to ensure she remains on the path of peace and accountability. I ask the court to consider her age. I ask the court to consider her today with leniency. Thank you, Your Honor, for allowing me to share what I have seen and the opportunity to acknowledge the family and their loss. And God bless.
Nathalie Powell.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You state your name for the record, please.
Nathalie J. Powell. Your
What is it
Honor.
you would like the court to know?
I've had the privilege of watching Jahara Malik grow up, and from a very young age it was clear that she was a really special young lady. She's always carried herself with a level of intelligence and awareness that was far beyond her years. That maturity also made her seem older than what she was. Jahara has consistently stood out as someone that was thoughtful and capable and exceptionally bright. However, I've also come to understand that being so advanced for one age can sometimes present its own challenges. When a young person is accustomed to being the smartest among their peers, it can create a sense of confidence that they are ready to handle situations that in reality, they're not. That kind of confidence, while rooted in strength, can sometimes lead to difficult decisions and unintended consequences. Jahara's actions should be viewed in the full context of who she is. A young woman with tremendous potential who's still learning and still growing. She's still in need of support and direction as she navigates these complex situations. I firmly believe that with the right guidance, structure, and encouragement, she'll continue to develop in the remarkable individual that she has always shown herself to be. Thank you for taking the time to consider not only the circumstances before you, but the character and promise of Jahara Malik.
Thank you. Nia Jackson.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
State your name for the record, please.
My name is Nia Jackson.
What would you like the court to know?
I'm sorry.
What would you like the court to hear from you today?
I'm speaking now as a character witness for Jahara Malik. To the Honorable Judge, I am writing this letter in respect for the court, and I understand how serious this situation is right now. My heart is very, very heavy for everyone that's involved in this. I want to first acknowledge the family who I know is grieving. Losing a loved one is something no family should have to go through, and I truly extend my deepest sympathy to them. I can only imagine the pain they are experiencing. I am writing on behalf of Jahara. I have known her since she was 3 years old, and she attended our school until 7th grade. Having her as a student was a true pleasure. From the first time she was a little girl, I knew her to be kind, to be loving, and respectful. She worked hard, she tried her best, and included others. She was also very bright and involved in school activities, including participating in writing, poetry competitions, and brain bowls. She took pride in her work and always pushed herself to do well. One of the most memorable things about Jahara was during our school showcase throughout that year. Not only did she take the time to practice and learn her own poems, but she helped younger students learn their parts too. She showed patience, she showed leadership, and a genuine care for others. She was known for her hard work and for looking out for those around her. This situation is very, very difficult to process because the person I know her to be is not someone who would intentionally cause harm. I truly do not believe it was malicious intent. I believe this was a tragic situation involving young people who did not fully understand the weight of their actions in the moment. Jahara is only 18 years old now. She is still growing, she is still learning, and still developing emotionally. I believe in my heart that she is deeply apologetic for what happened and that she carried this with her. She will carry this with her for the rest of her life. I respectfully ask the court to consider giving her grace and leniency. An extensive sentence will not only impact Jahara, but will also take away the future of another young life. While nothing can undo what has happened, I believe there is still an opportunity for growth, accountability, and redemption without completely closing the door on her future. I also believe a more meaningful form of accountability will be allowing her the opportunity to serve her community, giving her the chance to speak and mentor young girls about the consequences of their actions. On impulse and heightened emotions could turn this tragedy into a lesson that helps prevent something like this from happening again. I truly believe she can use her experiences to make a positive impact on others. This is a very painful situation for everyone. A family is grieving, and a young girl now faces consequences that will shape her life forever. I am not here to excuse anything, only to speak who she has been in my life and to ask for compassion as you make your decision, Judge. Thank you for your time, and thank you for your consideration.
Now you. Jahara Malik.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
State your name for the record.
Jahara Malik.
And what would you like the court to hear?
My name is Jahara Malik, and I stand before you today on the behalf of my niece, Jahara Malik. First, I would like to acknowledge the gravity of what has happened. A young man has lost his life, and there is nothing that can undo that loss. I want to express my deepest condolences to his family. I cannot begin to imagine the pain they carry, and I do not stand here to lessen that in any way. What happened was tragic, and Jahara understands that. She has taken responsibility by pleading guilty, and she will carry that weight of this for the rest of her life. I've known Jahara for her entire life. She is not a violent or careless person. She comes from a family that values faith, discipline, respect for others. She has always been someone who shows love to those around her, someone who supports her family, someone until this moment lived a life that reflected compassion and care. This situation does not define the entirety of who she is. It reflects a moment, a tragic mistake, not a pattern of behavior. Since this incident, I've seen the impact it has had on her. She is remorseful, she is reflective, and she understands the seriousness of her actions. This is not someone who is trying to escape accountability. This is someone who is already living with deep emotional consequences. Your Honor, respectfully, I ask the court to consider leniency in sentencing, not to overlook what has happened, but to recognize that Jahara has the capacity for growth, for rehabilitation, and for becoming a productive, positive force in society moving forward. Punishment alone will not bring healing, but mercy paired with accountability can allow something meaningful to come from this tragedy. Thank you for your time, and God bless everybody here.
Thank you.
Thank you.
Gloria Dosset.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
state your name for the record, please?
Well, it's really Gloria Butler, but Gloria Garcia. Butler, yes.
What would you like to say to the court?
Your Honor, as I said, my name is Gloria Butler, and I'm the grand aunt of Jahara. I stand before you as a character witness, someone who's known her all her life. My favorite term from Dermot has been Hara. That's how I refer to her. Because that means carries the warmth, the kindness that she always had as a child. Very sensitive. I've watched Jahara grow from a child into a young woman right before my eyes. She's always been loving. What always stood out was her compassion. She has consistently shown a deep sensitivity towards others and a genuine care for people. When this tragedy happened, the Malik family weren't just torn because it was their granddaughter, but because of the pain of your family. And they wanted to reach out. They were agonized, wanting to reach out. But when you have so many people in the mix giving so many different opinions, they were told not to because of the pain you guys were going through and the whole heated atmosphere that was going on at that time. And they agonized for your family. And I'm believing that if these two families can come together at the interim of everything and establish something in the name of your son, that can be a beacon for other young people. Let something good come out of this. And I just want to say, I can speak, like I said, to the impact on this family. They're not living in a place of celebration or peace, but in a place of deep sorrow and grief. While they're holding on to hope that they also will learn how to live with a reality that has forever changed everyone's lives. I have talked with Jahara after the whole situation, and I can assure you she's beyond remorseful. Though she stands here physically, and even that smirk that people say she has, that is a part of her coping skill. She's one of those, like, if she's uncomfortable with something embarrassing, you will see that smirk. That does not mean that she is not sensitive. That's how she deals with discomfort. She carries a heavy burden within her, one of pain, regret, and sadness. This is not something she can simply escape. It is something she lives with every day. Your Honor, it is my prayer that as you consider this case, you are guided with wisdom, discernment, and compassion. God bless you.
My last character witness would be Naira Russell.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Will you identify yourself for the record, please?
Naira Russell.
You're soft-spoken.
Naira Russell.
All right. What would you like the court to hear?
Dear Honorable Judge Christine Hernandez, my name is Naira Malik, and I am the aunt of Jahara Malik. I have known Jahara since the day she was born.
You got to speak up.
I was known Jahara since the day she was born. I was in the hospital on that evening, and I witnessed her very first moments of life. I recall that day with great clarity, just seeing a beautiful life come into the world. I want to take a moment to give my sincerest condolences to the family. I understand that you're grieving, and I understand that your pain is deep. And I have prayed for your family, just as I have prayed for our family. And I have prayed for peace for your family as well. I am saddened by the loss of life and suffering that your family is currently experiencing. While I do not excuse her actions, I respectfully wish to speak to her character and to the person I know her to be. Jahara has consistently been a very compassionate individual in our family, just like my great aunt Gloria said. She's always had a very strong sense of responsibility as well. When my mother became ill, Jahara Her and my mom has always been very close. But at a very young age, she took it upon herself to make sure that she had a way to and from to visit my mom. And while she was there, you never had to tell her to prepare meals, to assist with maintaining the house, and more importantly, she made sure that she sat and talked to her, showing compassion and care. At a very young age, Jahara also demonstrated initiative and discipline. At the age of 13, she taught herself how to braid hair. By the age of 14, she had established a steady clientele doing hair on the weekends and maintaining good grades as well. This level of commitment reflects her work ethic, responsibility, and determination. Over the past 15 months, I have personally observed Jahara. From the beginning, she has expressed genuine remorse and has taken responsibility for her actions. Jahara and I have been up several nights having conversations, just trying to understand what transpired on that day. She has taken meaningful steps towards rehabilitation, including participating in therapy and also seeking spiritual guidance. And I recall on some nights when I will wake up in the middle of the night and Jahara will be up walking around with nightmares or just persistent sleepiness and crying. And also thoughts of self-harm as well. During that time, I decided to stay home because I wanted to watch her, because I feared what she might do to herself. She independently told me that she wanted to make sure that everyone knew that she was taking accountability for her actions. Those efforts demonstrate her willingness to reflect, seek help, and make better decisions moving forward. I respectfully ask the court to take into consideration Jahara's demonstrated capacity for growth and the efforts she has made towards rehabilitation. Thank you for your time.
Judge, I would like to call a representative from boot camp, and then my client would like to address the court, and then I will see what the state has to say, and then I will give my closing remarks. Boot camp representative, please. Identify yourself for the record, please.
Good afternoon, Judge. My name is Officer Barry Antos. I'm one of the court liaisons for the boot camp program.
Officer, I'm familiar with you.
And did your program have an opportunity to conduct an assessment and an evaluation of Jahara Malik?
Yes. Once the court order was placed in our within the boot camp program, we had Ms. Malik evaluated psychologically and medically to be cleared for her to be able to be eligible to be a participant for the boot camp program.
And what is about the boot camp program that you believe will be beneficial as someone that's worked in the system, familiar with the boot camp as relates to Jahara Malik?
So the boot camp program was established in June of 1995 as an alternative for youthful offenders instead of them having to do prison time based on the charges that they presented at the moment of their arrest when they were incarcerated. The boot camp program is set up as a military-based program, so that way one of our main, one of the characteristics that we do, that we're very, that we feed off of is the fact that we take a defendant and we break them down completely and we rebuild them back so that way they're a more productive citizen to the community with different thoughts and different aspects as to when they first entered the program.
And the boot camp program is for individuals such as 17, 18, 19. How far do you go up for being eligible to participate in that program?
So the boot camp program takes participants from the age of 14 to 24.
Now, as part of the boot camp program, individuals who are facing life sentences, have they been admitted into the boot camp program?
Yes, we have had plenty of participants that have charges that are punishable by life.
In this case, Jahara Malik's sentence is a first-degree felony, not a life felony, which means less than that, right?
Yes, Judge. Yes, sir.
Do you believe that Jahara Malik will benefit from the boot camp, Miami-Dade County boot camp program?
I believe any young offender, whether it's Ms. Malik or anyone that comes into the system, can benefit from being in the boot camp program. A lot of times we forget to understand that the youth has a different mindset when it comes to how authority is or how they were raised, and they have a different way of thinking. Once they come into the program and they realize the reality of what our program is, they realize that at some point a change has to be made. And at times they're a change for better, some are not a change for better, but for the most part, if we can get them to change a little bit of their mindset and be a better person to the community, or a better person to place out there to show that there's growth for change for the youth, that's what our program stands for.
And my last question is, why is the boot camp such a beneficial program?
We offer a lot of different things when they're in the boot camp program. We teach them, one of the biggest things that we teach them is discipline and self-control. We do also provide them with anger management classes, life skill classes that they may never have thought of having or wanting. They learn, different trades while they're in the program. If they're not GED or do not have a high school diploma, that's one of our requirements, is that they leave with that extra certificate showing change, that they want to grow and they want to make a difference in their own life. Then when they're out in phase 3, our program is based on 3 different phases: phase 1, phase 2, and phase 3. When they're out there in the phase 3 portion of our program, they are to now become productive citizens in the community. They're to work, they're to go to school, they're supposed to do something productive when it comes to our requirements. We've had plenty of cadets that have come into our program that are now part of aviation companies, that have become aviation certified, because things that they never thought they wanted to have, they are now encouraged to do something different or better with themselves.
Thank you very much.
Thank you.
Judge, Jahara Malik would like to address the court, and I'll ask her to come forward at this time. Would you state your name for the record, please?
Jahara Malik.
Yes, sir. Please stay silent, sir, to tell the truth, the whole truth, and nothing but the truth.
Yes.
Can you have a soft voice? Can you speak up, please?
Yes. Good afternoon, everyone. Your Honor, I've been thinking about what to say for a long time. And the truth is, there are no perfect words for something like this. When everyone read a speech before they get sentenced, they ask for mercy. But I'm here to accept my consequences for what I have done. The night that everything happened, not one thought in my mind was to leave or run. I didn't want this to happen. I was thinking about saving someone else's life instead of myself. That's why it was a quick reaction for me to wrap his shirt around my hand, apply pressure to his wound, and stop the bleeding while communicating with 911 to assist me. I wanted him to live. I understand that trying to help does not undo the harm. I stayed because at the end of the day, I was at fault. I would rather live knowing I tried to help than live knowing I left him there when I could have possibly saved his life. I was reckless. That knife should have never been out, and because of that, a life was lost. I was wrong for what I did, and every day I sit and think about the damage I caused. The family wants me in prison, but I'm in my own prison for the rest of my life. I understand that I have to be very mindful when it comes down to this, to making decisions and being more, I can't see,
being more aware on choices that have consequences behind them. This situation forced me to sit with myself in a way I never had to before. I had to grow up fast. I had to reflect. I had to reflect on who I am and who I want to be. I know I can't change the past, but I can change how I am moving forward and become a better person than I was before. To his family, I know an apology cannot do anything for you all, but after that night, I tried numerous times to reach out. I wanted to call Miss Nat and his dad so bad just to tell y'all how sorry I am and beg for your forgiveness, but I couldn't legally. I love y'all son so much, and I never wanted this to happen to him. This was my best friend, my love, and someone I could vent to about any and everything. He was a good person and definitely should have been here. We would have been getting ready for prom and graduation right now. This is a sad situation. I miss him every day. I know there are memories, birthdays, holidays, things that will never feel the same without him. I wish I could go back and change what happened, but I can't, and that's the worst part. Y'all didn't deserve this pain, and I wish I hadn't been the one to give it to y'all. I pray one day the family could forgive me, and I want to say I'm sorry to his friends and his family. I know that I hurt y'all in a way that y'all can never forgive me, and I hope one day y'all can. When my mom that night after the detectives, I talked to them and they told me he was in surgery, and I knew something was wrong. I went to the room and my mom and my dad was there, and my mom was crying. And I'm like, why y'all crying? He's good, he's in surgery. My mom said the boy died and my life stopped after that. My heart was broken. All I could think about is him being gone. I just pray that we all heal from this, and I pray for closure, and this is a sad situation from both ends. My family hurting too. We know y'all hurting. We hurting with y'all, and we not against y'all. We all in this together. Like we fighting for me, but we're on y'all side. We're not against y'all. Yes, thank you.
Alright, I need everyone. Okay, Mr. Hanfield, do you have any other witnesses?
No, Judge.
Alright, I'm gonna ask both the state and Mr. Hanfield and Mr. McGee to just again represent or articulate what the recommendations are, and then I'm going to take a brief recess, and then I will come back to impose sentence.
Would Your Honor, can I take argument after we take a break?
No, I'd rather take argument now.
I just need a quick.
Oh, you need a break?
I just need a quick. I can run right there and run out.
Okay. No, then I'll take a break now. I will be back in session at 5:45.
Thank you, Judge.
All right, the judge.
But this is my first hearing. I'm
okay,
on.
so
Yeah. I just need something.
Gotcha.
Judge, what's start talking
from the record in the matter of the state of Florida versus Jahara Malik. We've been going at this since about 1 or so this afternoon, so at this time I'm going to ask the attorneys to complete their presentations with their ultimate recommendations.
Thank you, Your Honor. Kristen Rodriguez on behalf of the state. Your Honor, the state has, just so the court notes, the state has filed its motion. There's a lot of certainly case law and the statutes that the state would intend to rely on listed in there. There are a couple of things that I would like to highlight now that at the beginning we're able to finally note the two prongs that defense counsel was proceeding under, and that's prong J and prong L. So I want to start off with, as Your Honor notes, the primary purpose of the sentencing code is to punish an offender. Rehabilitation is the desired goal of the criminal justice system, but it is subordinate to the goal of punishment, and that is directly from Florida Statute 921.002. It is important to note that in this case, when a defendant pleads open to the court, the facts are as they would have been if the state had proceeded to trial. Part of what this court has to consider is every single exhibit that was provided to the court previously, prior to the hearings, so the court could have a full opportunity to review everything, and that has been admitted into evidence as in some states. Exhibit 1, the state provided Sergeant Santos as a witness today to sort of give the court an overview of all of those exhibits and sort of highlight some of the key things that the state would have pointed out through a trial. When we are looking at particularly defense's requests for a plea as to youthful offender sanctions, as this court knows, it's the court may, and then the second question for the court is should the court impose those sanctions. In particular, we are looking at prong J, which is the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse, and then prong L, the defendant is to be sentenced as a youthful offender. The case law is abundantly clear when it comes to prong J and prong L. Prong L in particular, the youthful offender, it is supposed to be considered independently of the other prongs. So for example, while remorse is something that is considered under prong J, under prong L, the case law is clear, it's irrelevant for for that prong. Something to be considered, but not necessarily relevant. When we're looking at prong J, Judge, as Your Honor knows, it's unsophisticated manner and was an isolated incident for which the defendant has shown, and there's remorse, right? So it has to be all three things. In this case, from the state's perspective, we don't believe that this was, in essence, an isolated incident. While Your Honor knows that there are no prior history here, when we look at this case and we consider what would have been the Williams rule evidence, which was touched on by Officer Santos and which Your Honor was able to read throughout the reports, there are multiple civilian witnesses that would have testified at trial, and that evidence is here, that the defendant had previously pulled out a knife, right, with the victim. She had on one prior occasion run around while they were at home, and one of the other kids who was there, who was young, had to in fact disarm her and toss the knife away. That was witnessed by 4 other individuals. There were prior instances of aggression between her and the victim, and where she's either been mad and broken his phone. But certainly the most striking thing is the knife. Because then when we flash forward to the date of incident, where from her statements, right, which have come out through the officer, it was, and through the statements in the reports to the doctors, it's her is, I pulled the knife out in the spirit of horseplay. When the state looks at sort of it in sort of the totality of the circumstances, we look back at her pulling a knife before. We look at the context of what's going on. She tells officers she has a knife with her for the purposes of protection, which, I'll sort of break down because I want to get into kind of the knife, but when you look at it kind of in context, the state's position is that it's really not an isolated incident. She does have no priors, but again, she's pulled out this knife before, and there have been other instances of sort of aggression between the two of them where she, right, was the initial aggressor. Then when we're talking about youthful offender, at least for the sake of time, Your Honor has it in my motion. Certainly she is eligible, but the question is, she's not necessarily entitled. It's up to the court now to determine whether or not that is appropriate in this case. And so I'm just going to cite a couple cases. I have provided them previously to Your Honor with respect to just unsophisticated and isolated, and I just want to put Staffney v. State on the record, 826 Southern 2nd, 509, which is a 4th Florida case that outlines sort of the the standard for isolated and unsophisticated, and isolated and shows remorse. And I just wanted to add also State v. Profit, 423 Southern 3rd, 15 and 18. It's the fourth Court of Appeals, the fourth district case that is directly to that prong. Again, I've cited some things in my motion. I just wanted to put those on the record for the sake of time. Okay. Judge, as Your Honor knows, we are here today because a young life was taken. Keimo was 17 years old. I know that everyone has called him Keimo, and I don't think that you've heard a lot about him. But one of the things that has always struck me is how he got his nickname, and his mom kind of touched on it when he was 3. They gave him a football, and the way she described it to me was juking out all the older kids. They literally had to yell at him to stop because he was just making his way completely down the street. And from that day forward, he became this kid who was so fast, and they called him Kimosabi. And so then it became Feed the Horse. And then for the rest of his life, he was known as Keimo, and it sort of speaks to what a tremendous athlete he was. And sort of the other thing that I do want to touch on, and I know you've heard from a lot about his life, but in particular from his mom, there's been something that has always struck at least the state. She has always said that her goal in raising, particularly her son, was that she always wanted to have a son that was just a good man. And how the loss of his life at 17, right? That's something that a mom expects to hear when her kid is in his 40s and 50s, hearing from all his friends. She, at 17, told me, I did that. And she knows that because it was a sort of a testament to kind of his life, how many people had come to her to say he was such a good person. And I think that was evidenced by all of the people that spoke today on behalf of Keimo. The one word that I think continues to stand out, particularly to the state, was good. And I just, I think that that's important for us to highlight because this case is tragic. And certainly for many reasons, but nonetheless, when the court is here considering a sentence, we also have to consider the life that was lost and the impact that has on not only his friends and his family, the fact that his mother and father will never get to watch him walk graduation, his mother will never get to dance with him at his wedding, walk him down the aisle, his aunt will never get to have him come over and be the kid that she remembers him being. His family and his friends will never get to watch him create this life of his own. Keimo's life, his friends and family are left here with a grief that doesn't diminish. It's just going to change and shape over time. And certainly, again, the sentencing of this court must account for that loss. I want to touch on a couple things that Your Honor has. In particular, I want to talk about the knife. I want to be very clear. And we've heard from 2 doctors who talked about the fact that the defendant was 17 at the time. That is a fact. She was 17 at the time. I do not believe that because she was 17, based on what we heard from either one of those doctors, that the defendant in this case could not appreciate the dangerousness of a knife. We know this partly because of what we heard from the officer when he talked about, she told officers, I had a knife for me for protection because I was taking Ubers. So in that own statement from her own mouth, she knows that a knife can be dangerous and can be used whether to protect herself or to inflict harm on someone else. I would also point out, she is 17, she is not 5, right? This wasn't something where she was, she is of the age where I think she can cut her food with a knife. It's not something where we're giving her a dull knife because she doesn't know how to handle it. There was no evidence with respect to the fact that there was any, at least diminished capacity, so to speak. There was no evidence that the testimony in fact was that she was very smart. She otherwise had a good home life, right? So there is nothing really to suggest that she couldn't appreciate the danger for what a knife was. And I think the other big point with respect to the knife is when we talk about the isolated incident, she knows that a knife is dangerous, and I'd point to 2 other things. One, the text. To whatever weight the court wants to give it, certainly it was admitted it was something where whether she was joking around about a knife, but that goes towards her level of recklessness and the fact that she knows, right? And it was, I stab, I want to draw blood. So that to me is knowledge with respect to the knife that she understands. When we talk about then the impulsivity that the doctors talked about, Your Honor, I think I would tell this court, we also heard from those doctors, again, she was smart, she was capable. We've heard from every witness here, at least that the defense has presented, that she otherwise had a good head on her shoulders. She, there was no trauma, no abuse, nothing, none of those, quote, red flags, like when I asked, the therapist that really stood out to them. And they also had to be honest, a very short meeting with her. She didn't really, it was all self-reporting, and she didn't really report some of the more serious things that were going on with her. In particular, the fact that she had previous issues of aggression between her and the victim, and she was the initial aggressor. The other incident with the knife, where 4 other kids are watching this whole thing go down, where she's pulling a knife and she's chasing him, right? And she's lucky nothing happened that day too. And so she almost got her mulligan, if you want to call it that, on the first incident where nothing happened, where they were able to disarm her. Then again, now we flash forward to the incident with the knife. The knife that she had in her purse, that would have stayed in her purse had she not pulled it out of her purse, right? She had to physically open the purse, pull the knife out, and then when we look at the wound that the victim had, you know, Your Honor got to read the full medical examiner's report. Detective Sergeant Santos highlighted, right, I think the things that should be highlighted, which are 2 big things. One, that knife went completely into the victim. It pierced his heart. The full blade, the full 4-inch blade, and we got to see it. It was a large kitchen knife. It wasn't a pocket knife. It was a knife that she pulled from the kitchen. It looked almost like a paring knife. The full 4-inch blade went directly into his chest. Her statements to police are, oh, well, you know, I'm holding it right like this, and I was holding it kind of right here, and he sort of walks into it. That is inconsistent with, at a minimum, the injury that he had. It's also inconsistent where he had the injury. We know that he's taller than her. We know that she's shorter than him. In order for her to have reached his chest, that knife had to have been out. And Judge, I would submit to the court, you know, as you've had the reporting, you've had sort of the facts, and you've heard her statement, for the knife, for her to have been holding the knife like this, the state would have argued at trial that it really wasn't like that. I think, quite frankly, she was holding the knife directly out because that knife went into him with such force. It penetrated not only his hoodie, his shirt, his muscle, his fat, it clipped his rib, and it went directly into his heart. There had to have been such force to have penetrated that, which had to have meant that her arm was out. And it was up because he gets stabbed in the chest. He doesn't get stabbed in the abdomen, which is where she tells police she had the knife. And that was what she tells police after the fact. Because before, when she's there, it's, well, I had the knife out, and then first it was, I got mad at him, so I pulled out the knife, right? Then it was, oh, well, I pulled the knife out because I was playing. And I would again submit to this court that a 17-year-old does absolutely know better. Whether we want to, and I understand the doctor sort of testified, the brain doesn't fully develop until 24, that's certainly understandable. There's certainly a lot of science with that. But again, that doesn't mean, and I think the second doctor said that too, and so did Dr. Brennan, doesn't mean that then she could not have appreciated the dangerousness that could have come from that knife. And what injury, what could have happened? With respect to the isolated incident and the fact that I think, you know, defense counsel again has stated previously, look, this was an accident. I think that, you know, when they argue that she pulls this knife in the spirit of horseplay, that the victim's death was this result ultimately of a choice to ignore basic responsibility, to consider this just an accident, as the defense sort of has stated previously, I think blurs a really important distinction. It's that an accident is something without foresight, without the reasonable ability to prevent it. And this case screams foreseeability, not only from the fact that she is 17 and she's pulling the knife out when they are, whatever her version is they're playing around. So she's pulling a knife out in that situation, right? But also foreseeable because she's done it before. So she's pulled out a knife, chased him around. So it's not that it's, you know, this one isolated incident. Again, it's something that is absolutely foreseeable. This was not, and again, pulling a knife in that situation is not an accident. They're not in the kitchen cooking steak where the knife, we trip and we fall, right? She intentionally pulled that knife out of her purse and introduced it into the situation with a person that she claims, right, that she loved and that she cared so deeply about. And I would also point out to the court, at no point, right, at no point, but in the PSI, because I do want to highlight that, at no point when she's meeting with any therapist, when she is meeting with police, does she ever at any time say, I was afraid of him, I acted in self-defense, I, you know, needed the knife because I was scared. The first and only time that she mentions anything at any point about her being in somewhat of fear of the victim is in the PSI, Judge. And, you know, the state finds that interesting. At this point, everything has become more serious. And so for the first time, when she's been with therapists for the last 15 months, not any therapist, and Dr. Brennan did say that he spoke with her other therapist, to sort of get a bit more context, and that therapist didn't tell her, hey, by the way, she's reported this. That is a relevant and important fact that I think if that therapist had known, she would have told Dr. Brennan, because again, all of the therapists also know why she's being evaluated and what is going on here. So for the first time, it is mentioned in the PSI. And I just think, Judge, to be honest, like based on the testimony and the evidence before the court, really the only evidence is that the defendant, was the only aggressor between the two of them. I think it's also evidenced by the fact that in the video, you hear him say, "Jahara, stop." He doesn't, and I think his dad made a great point. He at no point, right, put hands on her at all. He was bigger than her. He could have, and she stabbed him right in the chest, and he died in that moment. Judge, for all these reasons, for all of the reasons that the state has indicated in their motion, the state is objecting to youthful offender sanctions. I've laid out sort of the state's objection with respect to the case, and I know Your Honor has had an opportunity to read it, so I won't, repeat it all for the court. But the state is asking that the court not sentence this defendant, as a youthful offender, but to sentence her to a serious term of prison, including 20 years of safe prison and followed by 10 years of probation. For all of the reasons, for all of the evidence before the court, we are asking that the court sentence this defendant give the defendant, a serious sentence that reflects the seriousness of this offense and the value of the life that was lost in this case. And the state thanks you, Judge.
Thank you, Mr. Hanfield, on behalf of Ms. Malik.
May it please the court. First of all, I want to express my deepest condolences and the pain that I know that the family has suffered and is still enduring. It's important to me that you understand that I am sorry for your loss. And God is my witness, I understand that. I don't stand here to make excuses for it. What I think is important, there are three factors that I want to talk about. First factor is that Jahara Malik accepted responsibility by telling me, I didn't tell her. One, she did not want any depot statement because she knew that what happened, she did not want to happen, and she wanted to accept full responsibility. No matter, I've been doing this for a long time, there's very few clients that I have represented that told me, don't do what you're supposed to do, because I will accept full responsibility. I make no excuses. I didn't intend for it, but I understand that I was wrong. And for anyone who dismissed that, is not accepting what we do every day is try to get people. The first step of rehabilitation is owning up, I was wrong. Regardless of what happened, I was wrong and I accept full responsibility of that. Number two, at the time of this incident, she was 17 years old. Why is that important? You don't have to listen to me. Just listen to the expert, Dr. Brandon, who has testified on behalf of the state just as many times as behalf of the defense. said that why is that important? We all know that. We don't have to use common sense. That at the age of 17, there are certain behaviors that teenagers participate in that as adults we should know better. I don't say that as an excuse. I say that as a reality. That's number 2. Number 3 is that this was always described as horseplaying that went too far. Now, how do I know? I'm not going by what my client said. I'm going back. All you have to do is listen to that 911 call before the call, before anything happens. The conduct by the 2 individuals show that they were horseplaying. That video does not show about anyone going there with ill intent to do what actually happened. Because they're playing, they're running. I didn't make that up. The video, notwithstanding what anybody want to believe, that video is the best evidence of that. Then I look at her conduct afterwards. I've had many cases that I wish that the person acted like she did once realizing he's been stabbed. You can hear the certain things you can't make up. You can hear the raw emotions that was exhibited from that video when she called 911. How she's hysterical, how she's crying, screaming. And she tried at 17 years old to try to do everything for purposes of giving life-saving measures. Again, that is not conduct of someone who had a willful intent to do what happened on that day. What that is conduct of is someone that is immature, notwithstanding both Dr. Brennan said that, as well as the person who did the PSI. The first thing she noticed that she did not conduct herself at the age level. And she noticed that. And so why do I say all that? As sad as what happened should not have happened, it was a combination of being immature, reckless behavior that they have participated that resulted in a loss of life. So the question becomes then, what do we do with that? If she is put away, no matter how much time, that's not going to bring a lost life back. And I can understand from the family perspective that there's nothing that's going to satisfy. The question then becomes, what is fair and appropriate when you're dealing with a 17-year-old girl engaged in reckless horseplaying? Conduct resulted in us being here today. Throwing away the key, that's not solving the problem. Unless the answer is let's destroy 2 lives. That's not the answer. I've had cases where the person, they were not a girl, they were young boys, some older than her at the time, some as old as 20 years old, and they were looking at life sentences. And they were given an opportunity for boot camp. Why? Because the system understands that someone who has never been in the criminal justice system, you cannot just throw away the key. That's why we have these things. And it's about common sense. It's not about, well, just she made a mistake, so that's all that matters. Not when you have some things that is not in dispute. Not in dispute is that the conduct that was shown by both Jahara and the victim, before anything happened, they both were horse-playing. The conduct of which she did immediately once she realized what happened. That was raw, contemporaneous, and it showed the emotions. And now you've learned from several individuals, not one, not two, three, four, she's living with this. She's dealing with traumatic injuries, suicidal thoughts, trauma, based upon the predicament as to now what happened in that moment. If she had her choice, she would want to be in his place because that's why she wants to take her own life. And so therefore, if you have someone, and in this system, in this building, boys who were 18, 19, 20, and looking at life imprisonment, not 30 years, not 50 years, life imprisonment, but they were given an opportunity because the system understands. I wouldn't be having this conversation if she had been in the criminal justice system before. But she should not be treated any different for a crime that where she is charged is 30 years as the maximum and not life. And these programs are supported by our system because we know that it makes a difference. It makes a difference. And so I would ask this court, and I know it's difficult. I'm not going to pretend that it's not. But I do think that the right thing to do, the appropriate thing to do, by accepting and recognizing that she accepted responsibility, the raw emotions that were shown, not in this courtroom, but at the time, the video and the 911 calls, and the actions that she showed by trying to save his life. I believe that the appropriate sentence in this case would be a sentence that take all of those factors into consideration. Because we cannot have a situation where it's not good for a young girl, but it's good enough for a young man. That's just not right. That's not fair. And I know how difficult it is. Lord knows I know that. But I also know what happens in this building as long as I've been practicing law. When I was a prosecutor, I still understood it. And so I asked this court to understand that and recognize that for what it is. And I ask this court to take all of those factors into consideration. I thank you.
Mr. Hanfield, I cannot agree with you more regarding the importance of the boot camp program in this community and the opportunities that it has given to individuals who have made mistakes in their lives and given them the opportunity to rehabilitate them and be productive members of our society. But the two cases that you referenced in your motion are two cases, one of which this court was involved in. And I think it's worthy to note on the record that one of the cases did not involve someone losing their life. And it was a stipulation from the state of Florida, as well as the victims in that case, that agreed to have the individual enter into the boot camp program, so much so that the charges were amended so that he could enter the program. The other case, the facts of that case, they were best friends. And the family of the victim recognized that it truly was an accident, what occurred as a result of that individual losing their life. And that family, although in their grief and their sorrow, they recognized that it was truly an accident and that the individual that was charged would have never wanted or intended that to have happened. And so because of that, they agreed, and it was the state's recommendation to the court, a boot camp sentence. So I was hoping that you would give this court some guidance as to another case where the facts were similarly situated. I haven't received that from the defense. I haven't received similar facts from the state. I can tell you that this is probably the first case as a prosecutor and as a judge where there are two sides cannot be more far apart in what their recommendations are. And so I only say that to you because I want to acknowledge that in this building, I have exercised my discretion to give the boot camp program. But in exercising that discretion, I have taken into account what the victims have wanted. I've taken into account what the state attorney's office, law enforcement, what their recommendations are. And so that factors into the ultimate decision as to why boot camp. But I cannot agree with you more. I work with them day in and day out. They are a successful program. And when appropriate, boot camp should be given. So I just wanted to say that because I know you referenced in your motion those two particular cases, but I did look those cases up, and one of them I actually presided over. So in response to that, is there anything you would like to?
The last thing, Judge, obviously we objected to the text messages, and I indicated why. Because I know how that could be interpreted to exasperate or further inflame. And because of that, that's why, especially when I respectfully believe that there are certain evidence that is being attributed that I have not had an opportunity to test its validity to.
And I can tell you, as I stated, I will give it the weight. I think you're correct. They didn't establish what the time frame was regarding that, whether or not it was in fact Ms. Malik's text message. They laid a predicate to introduce the text message, but as I indicated, I admitted it, but I will give it the proper weight that the court deems fit.
And Judge, the only other thing is in that package that was provided by the state in reference to this interview of Ladari Williams, who is the person that is attributed to speaking about the casual poking or incidents of another occasion. The question during the interview, Mr. Williams, notwithstanding what he said, then he concludes, Mr. Williams added that during his relationship with Ms. Malik, she was nonviolent. And so it goes against everything that was being represented. At the end, even that person indicated that when it was all said and done, she was nonviolent. I just ask this court to reach a decision that I believe this court, I've always known this court to be fair and objective. And I would ask this court to take all of those matters into consideration. And I truly thank you for the privilege of being in front of you.
Thank you, Mr. Handel. I want to say first and foremost that this decision has weighted heavily on myself. I think the past couple of hours have shown this courtroom and whoever is watching that what occurred here was a tragedy. It should not have happened. And no matter what this court does, it's not going to restore the loss that your family has gone through and what your family will continue to go through. And I want to recognize that loss. The fact that there are the amount of people, the amount of letters, the amount of outreach on behalf of your son in his short life, the fact that so many people cared about him and loved him and are here to support him is something that everyone in this courtroom can say that we don't see it often. And his life was taken way too soon. And the court recognizes the profound impact that that loss has had. And I want to make sure I emphasize that. The court also recognizes that Ms. Malik, you are young. You are a young woman, but youth does not excuse what occurred that day. The law takes it into account and recognizes that it is your youth that affects your decision making and it affected your judgment. But your youth does not excuse the foreseeable consequences of the choices that you made. And Mr. Hanfield, I want to thank the state, I want to thank you, Mr. Hanfield, your representations today. You have all been professional. You have represented your client, you have represented the state of Florida in the best way possible. And again, it's a difficult decision. And so I first have to rule, Mr. Hanfield, you made a motion for downward departure under 921.0026, both J and L, and I'll address those respectively so that the record is clear. The defense has moved for downward departure based on the offense was committed in an unsophisticated manner and it was an isolated incident for which the defendant has shown remorse. The court will find that the defense has failed to prove by competent and substantial evidence and by preponderance of the evidence that that has been met. Although I do believe that you are remorseful, I do not believe that this was an isolated incident of aggression towards the victim based on the evidence that was presented here in court. And I also do not believe that this was done in an unsophisticated manner. And the reasons why the court finds that is the most dispositive evidence of what occurred that day was the medical examiner's report. And reading that medical examiner's report and understanding that that was a 4-inch blade that was lunged into the chest near the heart, and it pierced a hoodie, it pierced a t-shirt, it pierced skin, it pierced tissue, it pierced muscle, it fractured a rib, and it ultimately pierced the heart. The amount of force that was required to inflict that wound was not accidental. There is uncontradicted evidence regarding that report, the testimony regarding that injury, and I understand that Ms. Malik, upon the incident occurring, indicated at one point that it was a result of horseplaying, at another point indicated that she had her phone out, and Mr. Lollar ran into the knife. Those explanations are contradicted by the medical examiner's report. And so for this court, the court needs to look into the intent behind that and the foreseeable consequence of pulling out a knife, aiming it at someone, and subsequently stabbing them in the area where you have multiple layers to protect you. You have your skin, you have your clothes, you have your ribs. And the force that was used penetrated all of those and resulted in the fatal injuries that the victim sustained. So under that ground, the court finds that the defense has not met its burden by competent substantial evidence. The other ground that the defense is relying upon regarding motion for downward departure is 921.0026. Under L, the defendant is to be sentenced as a youthful offender. The court has found that the defense has met their burden by competent substantial evidence that Ms. Malik does qualify for youthful offender, but despite the court finding that she does qualify, there's a two-factor test, and that is whether or not the court can impose it, and the court finds that the court can impose it. The second factor is whether or not the court should impose it. And that's where this court has grappled, and this court has evaluated and analyzed, and I have gone over all the materials, not today, I've gone over it the weeks that it was presented to me, and the court has essentially come to the conclusion that because the sentence in this case must reflect the seriousness of what occurred, and because the sentence must reflect accountability, as well as the importance of protecting the public, the court cannot ignore the fact that a life was lost and the manner in which that life was taken. So at this time, though the court can impose youthful offender, the court will not exercise its discretion to impose youthful offender. So then what is the appropriate sentence? Ms. Malik, I have taken into account the documents that were presented on behalf of you, the evaluations that were conducted, the testimony that was presented here today, and the court does appreciate the comments that you made here today regarding how remorseful you are. And I think someone said it best, nobody wins here. And hearts are hardened, rightfully so, but one day, hopefully, there can be forgiveness towards you. You are very young, and you will still have a life ahead of you. You will still have an opportunity to become the nurse that you want to become, to have a family, to be with your family. But you have deprived Keimo's family of that. And for that, there needs to be a punishment. And the primary purpose of the Criminal Punishment Code is first and foremost to punish an individual for the crime that they're accused of, to punish the individual for the crime that they have been found guilty of, and to appreciate what has been lost and the gravity of what occurred. And so, because of that, I do believe that you're amenable to rehabilitation, and I do believe that you will get past this, but you have to be punished for it first. Because they have a life sentence of not having Mr. Lollar with them. And I can't overstate the profound impact that loss has been on their family, on their community, and the choices that you made affected the trajectory of all of their lives, and it affected the trajectory of yours as well as your families. You come from a very strong family that supports you, and they will support you throughout this, but the court needs to look at what is the appropriate sentence in this case. So at this time, I'm going to ask Ms. Malik to please rise. Ms. Malik, having heard from the state attorney's office, having heard from members of the public, having heard from the families, having heard from the doctors that testified, the court imposes the following sentence. At this time, the court will adjudicate you, Ms. Malik. The court will sentence you to 17 years in Florida State Prison, followed by 5 years of reporting probation. Special condition of that probation, you will have to go a mental health evaluation and abide by any treatment if necessary. You will have to write a letter December 20th of every year that you are on probation, acknowledging what had occurred and how it has affected your life. And I do not take this sentence lightly, Ms. Malik. This is not something that this court wanted to do, but I have to impose a sentence that I believe holds you accountable, recognizes the severity of the offense, and is something that's appropriate in light of everything that I've heard. So at this time, she will be remanded into the custody of the Department of Corrections to serve her sentence. Count 2 will be adjudication, 5 years. Please. 5 years. Then adjudication. 364. I'm going to appoint the office of the public defenders.
Judge, 364 for the prison.
Yes.
Everything safe? Perfect. With this, I'll, you ain't gotta worry about that. I'll say that name. I'll say that name.
Yeah, it's right here in this book.
Okay, perfect, perfect.
That's why we never.
Thank you. Let's make a judgment. Okay.
AJ, you got the judge to sign this whenever you got a judge. The judge to sign this.
I got it before she leaves.
If not, I'll see like I can get the judge to sign it.
Yeah, I'm going to